Now, Mr. Cody, we're going to proceed. You're going to be asked questions by Mr. Dillon Malone. Thank you. Yes, Mr. Dillon Malone.
Thank you, and good morning, Mr. Cuddy. Good afternoon for us, I suppose.
Yes.
Yes.
Good afternoon.
Thank you. Now, I'm going to address maybe 4 areas today, and I hope we'll be able to navigate where we need to better than yesterday. The first thing I'd like you to look at, please, is page B201. And this is a clause in the contract. It's clause 2.2. It's on page 201.
Again, page 201?
Yes, page 201.
Yes.
And halfway down that page, you'll remember yesterday that we had a brief exchange on the question of whose risk it was for government-related delays, including permit-related delays. And I think you indicated that it was Panther's risk. But if you see clause 2.2, it says the contractor is fully responsible to obtaining in good time all required permits, licenses, and approvals for the work, and acknowledges that it accepts the entire risk of any delays in obtaining all such permits. And then if I could ask you please to look at page B215. 215.
Yes.
You'll see right down the end of that page, there is a clause 8.5. It's just above the stamp.
Yes.
Yes. Yes. And in the FIDIC conditions, there is usually a clause which allows for some government delays to be put on the side of the employer. But in this particular case, that clause was deleted. Do you see that? It says delete this subclause and replace with not used. Yes. So I'm suggesting to you that in this contract, it's quite clear that any government-related delays would be on your side rather than on my client's side.
Okay.
Thank you. And then could I ask you, please, to have a look again? We looked at a letter yesterday dated the 3rd of November from MESC, and it's on page D1250.
2150.
1250. And we looked at this for a different purpose yesterday. You may remember yesterday. When you find it, just please let me know so I can. Have you found it?
Yes, I find it.
Oh,
3
very
November.
good. Thank you. And you'll remember yesterday we referred to the last paragraph of that about the question of mutual agreement. But if you go just above that to the paragraph just above that, further, it brought to our surprise that the employer's recent action of liquidating the performance bond and advance payment guarantee is on unjustifiable grounds. Regrettably, we record that the employer has no right to liquidation above where the contractor is not in default, and needless to highlight that such actions which adversely affect the contractor's future performance, where MESC was in full force during last few months to achieve the completion of works on or before 31st of December 2019. And I think from that sentence, MESC was saying to my client, if we weren't in default, therefore you didn't have any entitlement to liquidate the bonds. But I think it's accepted here in this paragraph that if MESC was in default, there would be an entitlement to liquidate the bonds. Do you agree with that?
No, of course, I not agree. We are not default.
Yes.
This letter date 3rd of November. This letter has already liquidated this guarantee. Already done. This
yes.
date He is already done. This meaning already before 1 day, 2 day, he sent it already to bank for due.
Yes.
Yani he have his plan. Yani must when will be, if he want do liquid guarantee, must he at least he will send it to us. Must
Very
he will
good.
let know us will be no. And in same time, without know anything, we are waiting him in 3rd November. Must he send it to us? Memorandum of understanding with signature.
Yes, thank you. Can we just turn then, please, because I don't think Justice Field has yet seen the liquidation documents. I'd just like you to have a look at them. They're on page, excuse me, D898, D898 to D901D.
Which page number again, please, without D?
898.
898. Yes.
Yes. And we have these are the letters by which my client liquidated the bonds that are addressed to Emirates NBD. And for example, on page 899, in relation to the performance guarantee at paragraph 3, excuse me, the performance guarantee is stated to be unconditional and payable in each on the employer's first demand without the contractor or any person on his behalf or ourselves, Emirates NBD, having the right to suspend or delay payment or to object thereto for any reason whatsoever. And then, can I just please refer you to it first, and then of course, I'll give you an opportunity and ask you indeed. At paragraph 4, then, it says the contractor is in persistent and fundamental breach of several express obligations under the contract, and the employer has suffered and continues to suffer significant losses and incur substantial costs on account of such breaches. In this regard, the time for completion has already elapsed, but the works remain incomplete, and the employer's entitlement to delay liquidated damages has fallen due. Such amount is immediately payable pursuant to clause 8.7 of the contract. And then at paragraph 5, it goes on to invoke the right to call the guarantee. So I'm suggesting to you that in this particular case, by reason of the breaches of contract which had been drawn to your attention over many months, my client was entitled to call those liquidation, to call and liquidate the performance guarantee and the advance payment guarantee on the 28th of October.
Okay.
And remember, the day before, the 27th of October, we had the meeting in which it was made clear that in an open-ended way, the works would not be resumed unless the memorandum was agreed to. Is that correct in terms of the sequence of events?
Okay. And that meeting, I can answer?
Yes.
Yes, please answer the question.
Okay. In that meeting, 27 October, we are meeting in the site. He is never speak, he won't do anything. He keep it secret because he have his off plan. And we feel he will not fair with us because he take this memorandum of understanding for sign after we discussed 2 months about this, what I said to you yesterday. But in the, we have no issue about what condition in the bank guarantee. He can do it. Yes, this no any condition he can do it. I have no issue in this one. This documented like this. Okay, but question, we feel he cheating us because he not tell to us. Yani why he have off plan and he let us with every day we meeting in the site and we solved all problem in discussion. And he finally we find the letter from the bank. He let us. We have some liquid your guarantee, but our client he not say anything to us, and this means He have his different plan when he will let we stage our time with 2 months. We discuss about memorandum of understanding. And what main reason, please, this meeting in 27 in October, what happened in the site? That time we have a big problem. I mentioned in my statement in the witness statement about delay of aluminium facade, about balcony handrail. That company subcontractor in same date and the October 27, he sent it to us letter for termination our subcontractor for aluminium. Why? He is give a program, he want long time for complete job. Why? Because in the end August, when he give engineer, when he give him approve for design drawing after with variation or after long time discuss, that time our subcontractor, he sent his program, he won't finish in February 2020.
Yes, let me help you there. Can I help you there, please?
Yes.
That letter was sent on the 28th of October by Petra to MESC. It's at page Q8041. I don't propose to open it unless you want to have a look at it. But that letter pointed out that a balance of money was due of about 590,000 dirhams.
Yes.
And you were in dispute with Petra at that time, isn't that right? Okay. You had a disagreement with Petra, and it was your responsibility as MESC for the delays of the.
Okay, we have agreement with Alberta, but this agreement will be changed design. He have some variation for time and cost because he changed design. What he give him approved drawing, he is not accepted continue without variation. He wants money. And this what partner he is not accepted. And he will take time up to finalize it. How this day in the August, in the end of August, he give him approved drawing for balcony handrail. How will be complete this approved after our contract time finish?
I understand. Thank you,
Mr. Kurdi. I understand the point that you're making, and indeed you made essentially the same point yesterday. Your case is that you were misled by Panther, that they went along with the idea of the MOU. They induced your side to sign and indicated that if you handed over the signed memorandum, then the next day they would sign it. But instead, a day or so later, you get a letter saying that the MOU is unacceptable and then guarantees are liquidated and so on. Now, I understand that perfectly well to be part of your case, so do bear that in mind. You don't have to repeat this part of your case. It's fully understood and it's on the transcript. I also want to say this, whether or not the guarantees were lawfully called is essentially a matter for the court. It's a matter for the court to make findings of fact and then by reference to the wording of the guarantee to decide whether the guarantees were lawfully called. And so to some extent, the fact that it's a legal question, I think might persuade counsel to move on to another topic.
Indeed, I had intended it to be very brief, just to show you the letters. Indeed, thank you, Mr. Kurdi. And I think you knew at this stage from the letter of the 6th of July and the correspondence of July and the dealings with which we discussed yesterday in July 2019, that you knew that our client would regard suspension as a very serious matter. Isn't that right?
Suspension?
Yes, to suspend works
No.
Our client had told you in writing through its lawyers on the letter of the 6th of July that we looked at yesterday, that Panther would regard it as a very serious matter if works were suspended.
Okay, but will be never suspended work.
Did you know, Mr. Curdy, did you know that?
Of course, I know this
Thank
letter
you. And
comes.
thank you. And you also knew on the 3rd of November from the letter that we opened yesterday that our client said that using your own default as leverage would be regarded by Panther and was regarded by Panther as unscrupulous and untenable. That was in the letter we looked at yesterday. So you knew that this ultimatum to my client and the suspension of works was a very serious matter for Panther.
Okay. Yesterday I told you, and I can repeat it now, we are never suspended work. When he sent the termination letter, still we are working. He kicked out from project. We never suspended work. Never stopped. Never up to last moment we are fighting for we complete our work.
Okay.
Well, let me, wait a minute, Mr. Curdy, we understand that. Everyone listening to you understands that.
Yes.
What you were asked was something different. Just listen carefully. You were asked to accept that you knew that if work were suspended by Merck, that would be regarded as a very serious and damaging matter by Panther, that you were aware that that would be Panther's reaction if you suspended work. That was the question. And what's your answer to it? Did you appreciate that Panther would take it very seriously if you did suspend work or not?
Yes, we take seriously. We understand, but that time we make as every other day we have meeting with him and we discuss this in general notes. He sent it by his lawyer office to us, but we reading, we receive it, but we are not affect to our work in the side. Related, he won't support himself. Yes, we care. We take this serious. What we received letter from Al Tamimi office. Yes.
Very good.
All right. Thank you very much, Mr. Kurdi.
Thank you. Well, can we turn to page 1051, 1051.
Page number
1051.
1051.
Yes. Okay. And we have here the notification to you from the engineer on the 4th of November that you had suspended works on site starting from 4 p.m. the previous day on the 3rd of November. Is the engineer wrong about that?
Yes, this engineer is totally wrong. This letter, because a client Panther, he guide him. And we are not suspension work and will be continue work. This is not right. This is not correct. And this guide him by, because I told you he have his open plan. He knows what he do every day. He send it letter, but we are not suspending any work. Suspension work. This not happen. This letter not correct.
Okay. Can we just scroll down then, please, to see there are a number of photographs taken on November the 4th. And you'll see between that page and page 1061, there are a number of photographs of an empty site with no activity taking place. Do you see that?
If you just scroll down from the letter,
yes,
you'll see the photographs. If you just go page by page.
Some of the photos, I'm sorry, some of the photos are on November 3rd at 5 p.m. And then there's a number of others stamped the following day, in the morning. So where are the laborers? Where are the workers? Where is the activity?
Okay, we have this our work already. We have above 90%. We no need that much labor there in the site, but we are working slow rate, maybe slow rate available, but we are never suspension work. Suspension work, this not happen, and I told you this not right. Our labor there, activity there. And we are working up to last moment. Our subcontractor came. His security, he brings security company. He keep it in the gate, and he is not allowed people enter to site. But this letter come from engineer related to instruction by partner for he have his off plan. But
Okay.
this not.
Can I just ask you, Mr. Kurdi? You say that there was activity on site on the morning of the 4th. Did anything change between the 4th and the 6th?
Yes.
What changed?
This work continue. Our people there. We make it this balcony upstanding. Our labor working, and but slow rate, yes, because in same time we have daily meeting with him, and we have go for finalizing our memorandum of understanding.
Well,
not that. Yes.
Yes.
Our engineer.
Let's see. Let's just
staff,
take a look, please.
Sorry.
Can we just take another look at what the engineer was doing? I appreciate you seem to be suggesting that the engineer was biased and was taking instructions from my client. That seems to be what you're saying. But let's have a look at the letter on the 6th of November on page 1064.
Page number
1064. I'll go back to that. This is a notice that you denied the DEWA inspector access on that day, yes? And then if I could ask you to look at the previous page, 1063. This is a letter addressed to you. Do you see this letter from Petra?
This letter from Naja is date 6 November, yes.
No, there's another one, the page before, 1063.
We can't scroll it. He'll have to put the number in again. Can you
see.
put the number 1063 in, please, Mr. Kurdi? 1063 and then click Find Page.
Yes.
Yes.
163, this
1063.
Okay, this is from Alberta, yes.
Yes, and this is addressed to you with reference to the phone conversation you had with Mr. Mustafa, and as per your instruction, we are stopping all the works at site related to aluminium and glazing works from today afternoon at 4 p.m. As per your instruction also, we will not be sending our workers from tomorrow onwards until you sort out your issue with your client and until you write back to us. And this is for your information. So this letter, Mr. Kurdi, indicates that you had a conversation with Petra and you instructed them not to come to on site. What do you say about that?
This letter, Petra, he sent it about our project manager. He knows this. He is liquid guarantee for this one. He let him slow down. Let will be understand what he wants. Client. This date, 3rd November. When will be know this is liquid our guarantee? Yes, we tell to subcontractor. We are never stopped 100% because our team there. But as this subcontractor, he is not working that much hurry because we want to clear our relation with the client.
Okay, so you saying you didn't, although it is addressed to you, the letter, says, dear Mr. Abdulaziz, with reference to the phone conversation you had, are you saying you didn't have that conversation?
But please let me complete. But this letter coming from subcontractor to us, because this day I told you our team there. يعني this who tell him stopped work? Who told him? How he knows stopped work? Our team there. Our team not tell him stopped work. Our team he know this what happened for liquid guarantee. He told him wait will be make clear with the client what he want. This day by day.
So you're saying that I take it from that there was some discussion of the liquidation of the bonds between Maersk and Petra. Is that correct?
Yes, that time, of course, we have discussion. We have daily, I told you, from 27 October up to 6 November, daily we have meeting, daily we have discussion.
Thank you. So I have to suggest that all of these actions by you were very risky.
Yes.
And you were taking a very serious risk in suspending works and indicating to my client that you would not resume works until the memorandum was agreed. Do you accept that what you were doing was taking a big risk?
Big risk about what?
Well, you were risking the project. You're risking the viability of the project for a start.
No, this related to client, to our client, related to partner. This not risky. How he go the liquid our guarantee, and he have not signed our memorandum after we discussed 2 months. How? What you want from us? How will we continue?
Okay, very good. I think we'll move on now, Mr. Kurdi, and if I could ask you please to look at page 11587. 11587.
11587.
Yes, this is a passage from the judgment of the Dubai Court of First Instance that was delivered on the 29th of June 2020.
Yes.
And the judgment begins at page 11582. But you can take it from me that this is the judgment of the Dubai Court of First Instance in your first set of proceedings. And if we just look at that big long paragraph, if you can find the reference to about halfway down, whereas the court has reviewed clause 20 of the contract. Do you see that? About maybe 10 lines down.
1 minute, please.
Whereas the court...
1158, yes. Now I'm with you, please.
Thank you. 11587.
Yes, what you want from here?
The very big first paragraph, about 10 lines down.
10 lines down, okay.
Approximately. It says, whereas the court has reviewed clause 20 of the contract.
Yes.
Okay. And the rest of that then passage states the court's finding that clause 20 was a binding jurisdiction agreement as in favor of the DIFC court, which was in clear and express terms. And as a result of that, the Dubai court did not have jurisdiction. Do you remember that?
I'm reading 1 minute, please.
Yes. Yes.
Yes. Now,
do you remember this judgment? Do you remember the court delivering the judgment and saying they didn't have jurisdiction?
No, I not remember.
I see. Okay. Do you remember taking further proceedings after this judgment? The The real estate grievance proceedings. Do you remember those where you sought to attach my client's assets?
This come to us later. يعني I not remember. I not care about this one.
Okay.
يعني this one
Well,
will be arrived to us.
Very good. Can
Then
I show you?
After we are totally go out, this one will be arrived to us after we go and handing over project to other contractor. I not care that time. I
Okay.
not
Very good.
this.
Well, you
Yes.
see, in your own witness statement, you do refer to these second proceedings at paragraph 18 of your witness statement.
Yes.
And that's at page 284.
My statement.
Yes, your witness statement.
Yes.
Paragraph, page 284.
Page 284, let me see.
Paragraph 18.
At the bottom of the page.
248, okay, in the bottom.
284, not 248, 284. Do you see that?
1 second, please. (284). Rest now I am here.
Yes. I state that the real estate grievance appeal number 72021 is a process which the defendant is entitled to attempt. And the allegation raised by the claimant that the appeal has been initiated in bad faith and as abusive process of law is denied. So you say that you were entitled to attempt it, and I think from that word attempt, you appreciate that there was a risk that your second Dubai court proceedings would not succeed.
Yes.
You accept that there was a risk. And you accept the consequences then of the Dubai courts not finding in your favor and declining jurisdiction. You took the risk, therefore you must accept the consequences. Is that correct? Perhaps I'm not making myself clear. Do you agree with me that by taking the risk and attempting these second Dubai court proceedings, you also took the risk of the consequences if the proceedings failed?
Let me please, I try understand from you. What you mean about Dubai court? Dubai court, what we casing in the Dubai court case?
Yeah, this is your evidence, Mr. Kurdi.
Yes.
This is your case. You're saying that you were entitled to attempt this second set of proceedings after the Dubai Court of First Instance had already told you that Clause 20 was binding, and after indeed you'd had a default judgment issued against Maersk in this court, and that you submitted to the jurisdiction of this court before all these events. So I'm asking you, if in the risk that you were taking, you accept the cost consequences? You knew that there would be cost consequences if you failed.
Let me please one by one. Now, which clause in this page 248 you are reading?
Paragraph 18. It's your evidence.
18.
Yeah, it's your evidence.
Okay. Yes.
Okay. So do I need to say it again? I'm just asking you to agree with me or not that
Yes.
if you lost those proceedings, that there was a risk, and you knew about that risk.
Okay. This our risk. Okay, I can. What I tell you, this what reason he bring it in his case, this already I answer, yani.
All right.
This not correct.
Well, I have to say that if you had had confidence in your case, you should have come
Yes.
to the DIFC court. Do you know that the DIFC court has a power to grant injunctions?
Yes.
Yeah, you know that. So you could
Yes.
have come here all along
Yes.
if you had confidence in your case and if you wanted to stop my client from terminating the agreement, you could have come to this court.
Okay. But okay. Continue. What's your question, please? Okay.
Well, I'm suggesting to you, Mr. Kurdi, that you
Yes.
didn't have confidence in your case and that you were attempting to sow confusion in the Dubai court and
No.
attempting to hamper and frustrate my client.
Okay. I can explain, please. That what happened when he sent the termination to us and he bring it security company, he is kicked out to all our people, and we sent it our security manager. He go to there, somebody from his company, he kill him, he broken his head, and we call police come and he make it report, huh? That time police, he guide our team go to Dubai court for open case as personal. What other guy he hit him for this from here will be go to other court. We know in our agreement if we have case will be go to DIFC, but this reason happened because this personal case for somebody from partner kill our security manager, and he go to hospital, and he open case, he transfer him to Dubai court. In Dubai court, what happened? Our some lawyer from company, he follow up, he casing this case as personal related to project.
Very good. Can I just, now that you bring it up, because I did want to ask you about that, but I'll do it now. Perhaps we just have a look at page 1235.
1235.
And there are a number of reports of this incident. I think you're referring to the site invasion on the 14th of November 2019. Is that right? When you're referring to these events? The 14th of November. Do you remember that?
No, I not remember. What's this letter? I not remember.
Okay, let me forget. Just let's take it in steps. The incident that you were just referring to, I believe, happened on the 14th of November when a busload of MESC laborers arrived at the site and broke into the site and forcefully broke into the building. Do you remember that?
Let's come to enter permission security guard. 14 November.
And there are a number of reports here on pages 1235, 1236, and 1237 to 1238.
Yes.
And these are the security reports from the security companies,
yes,
plus the report of the engineer.
Yes.
And the bus, I presume that the busload of laborers that arrived, they didn't just, that just didn't happen on its own. Somebody planned it, I take it.
Okay.
Yes. And
yes,
were you involved, Mr. Kurdi, in the decision to send
yes,
a busload of labor? That was your decision, was it?
Yes.
And what was the purpose of sending your employees after termination to the site?
Yes. This one, after what I told you, after this day, from after 6 up to, from 6 November up to when municipality تراخيص, he guide us and he give permission to other contractor. And that time, yes, we are not allowed anybody, we try not allowed anybody enter because this project still under our responsibility. And this what partner he do, he brings security company and kick us, this totally wrong. Why he do like this?
Okay.
After this one, we try this 14 November, what the security company, what he say, this report, this okay, we are told him, this project, our project, under our permission, under our responsibility.
Okay.
We try told him and tell partner, we are ready handing over project to you by right way, not by security company.
I see.
When he
Can I just
go to when he
Yes.
go,
Just let him finish this part, please. Carry
please.
on, Mr. Curdy. You're just telling me that you regarded you thought you had a right to carry on working, and you sent. I take it that you sent
we have right what again, sir.
You're telling me that you were of the opinion that you had a right to carry on working at the site, and
Yes.
so you sent the workers to go to the site.
Yes, I told you we are not leave it site up to 27. When that day, when he sent the termination, we never leave it site. We are continue up to date 27. When that building permit come to other contractors, that day we are leave it site. Before this under our name, under our responsibility, we are not leave it site.
Yes, but this document we're looking at refers to what happened on the 14th of November. And what it's saying is that a bus full of your workers arrived at the site and forced their way in, and there was a confrontation with the security staff. And in the light of that confrontation, the police were called. Yes. And a video was taken of the event by one of the guards. Now, can I take it that that's what happened here? That a busload of workers, your workers, arrived at the site and tried to get into the site, and there was a confrontation with the security firm. Is that not what happened?
Yes, sir. Yes, some touch come between our team and his team, because he bring two security company and he try take it this gate, and he not allowed our team for enter a project. And this our material, our equipment, everything inside. We try our people, our labor, our worker. He try take his equipment, his tools. But this security company from partner not allowed him for he enter to site. That time some touch come between our team and his team. But he kick our team side and he kill our people. He hit his head, our security manager, and he take him to hospital, and judge in the Dubai court already he give him penalty and he pay penalty, and this one he by power he won't not allowed us we enter to our project, and still project under our responsibility, under our permit. He cannot take by wrong way, by right. When will be respect regulation, local regulation, municipality regulation? We go to municipality.
All right.
Okay. Thank you.
I've understood your explanation of the event. Thank you. I think we can please move along.
I just before we leave this, I do need to. My client specifically wants me to put this.
No, by all means.
If I could ask you again, there's a NAGA report at 1237. That's the engineer's report.
1237.
Yes.
Yes.
And again, this report confirms what we've just been looking at. but the last two paragraphs on that page. Around noon, lawyers for MESC and Panther arrived at the Jebel Ali police station. After hearing testimonies for both parties, the police recorded a complaint from Panther against MESC actions, and all participants left the police station. Afterwards, the client, assisted by the police, went back to the project's construction site in Al Furjan, where MESC labourers still occupied the ground floor of the building and wouldn't left the construction site despite instructions from the police and the client. Additional police forces have been called to assist. Total of 4 police cars and about 8 officers arrived. And it wasn't until around 4:45 p.m. that MESC employees left the building. As per police instructions, the fence has been repaired and client's security company took over control of the site of the access. Is that an accurate description of what happened?
I not find anything what you say 1, 2, 3 this page, not what you are reading, not available here. Again, please, number 1, 2, 3.
1237. I'm sorry, Mr. Kurdi, I hadn't appreciated. It's
Ooh,
page
1237.
1237.
Now, okay.
And it's the last 2 paragraphs. I'll let you read the last 2 paragraphs.
This is 14 December 2019.
Yes.
That's right.
Okay. Still report MESC attended enter site building. Yes. Yes, now what your question, please?
Are the last 2 paragraphs accurate? Is the engineer recording what actually happened?
Okay.
And then above that, the third last paragraph, while the case was being discussed at the police station, MESC workers continued to occupy the building. Around 12:30 p.m., employees of Petra were seen carrying out window frames and other accessories from the construction site, and they were apprehended by security guards and police, and the incident was registered by the police, and the employees were transferred to the police station for further investigation. So there was some theft going on the day, isn't that right?
This report in the 14 December, I told you that time we are continue from 6 up to 27. Many things happen and we are responsible with our project. That time we try close the project and we go by right way from government and from Tarakis, from municipality. We are handing over by right way.
Mr. Kurdi, do forgive me. I'm sorry to interrupt you again. You're being asked whether you agree that what is set out in those last 3 paragraphs on the page accurately records what happened on that day. That's the question. If you'd focus on that, do you agree that this is an accurate record of what happened on the day as set out in the last 3 paragraphs on the page? It's either yes or no. You either do agree or you don't agree.
No, we are not agree.
You don't agree that this is an accurate statement of what occurred in these 3 paragraphs?
Yes.
Okay, thank you for that. I'd like you please to, you've mentioned a number of times and we'll be concluding quite soon, I hope, but you have mentioned the permit question, and you were saying that your name continued to be on the permit during this time. And can I just ask you please to turn to page 125. 125.
Page number
125.
Yes.
125.
And if I could ask you, just let me know when you found the page, please.
Yes, I find page.
Thank you. And you'll see on the second paragraph, the contractor shall then leave the site and deliver any required goods, all contractor's documents and other design documents made by or for him to the engineer. However, the contractor shall use his best efforts to comply immediately with any reasonable instructions included in the notice for the assignment of any subcontract, and for the protection of life or property, or for the safety of the works. And then it goes on to say that after termination, the employer may complete the works. And then I won't ask you a question for a moment. I want you to read this together with the amendment to it, which is at page 225, please. 225.
225.
225.
I'm sorry, yes, it starts on 225, but the portion I want you to look at is on page 226.
226.
226. The bit I would like you to read, it starts with insert the following as new paragraphs at the end of the subclause. You see the bit where it says within 14 days. Do you want me to read this passage out, or will I let you read it yourself? I want you to read from within 14 days all the way down to the performing such works, so before 15.3. Would you like me to read it?
No, I don't. What you this which clause? Where what you want from this page? 226.
226. You see where it says within 14 days of the employer's request to do so. And then there's underneath it, there's A, B, and then another paragraph. You see that?
Yes.
Yes. I'm offering to read the entire thing for you, if you, or perhaps you'd prefer just to read it yourself.
You can read.
Okay. Within 14 days of the employer's request to do so, the contractor, in respect of any termination of the contract, whether pursuant to subclause 15.2, 15.5, or 16.2, shall A, execute a letter of release in the form reasonably required by the employer, addressed to such authorities as the employer may specify from time to time, which, among other things, shall give the contractor's consent to any consents, approvals, or permits in connection with the works or the project being transferred to the employer, or to any alternative contractor engaged by or on behalf of the employer for the project. Any termination by the employer shall be deemed to have been effected with the mutual consent of the parties and without any need for a court order. And B, provide the employer with certified copies of all subcontractors and procure that such subcontracts as the employer may specify are novated from the contractor to the employer or to such person as the employer may specify. It goes on to say, if the employer is entitled to suspend the contract on account of the contractor's breach or terminate the contract without prejudice to any other entitlement, the employer may in its sole and absolute discretion take the whole or part of the works, including the part that is subject to the breach, out of the hands of the contractor and either perform such works itself or engage a third party to do so at the entire cost and expense of the contractor, including to the extent that the works performed by any alternative contractor are more expensive than the amount that would have been paid to the contractor under the contract. In this situation, the employer or any third party engaged by the employer may use the goods free of charge when performing such works. So I have to say to you, Mr. Al-Kurdi, that this was your agreement with Panther, and it's clear and extensive. It's crystal clear in providing for an extensive duty of cooperation with my client in circumstances of termination. This is your agreement, isn't it?
Yes, this is our agreement. And if any clauses in agreement, if not matching with what authority regulation in UAE country, must will be follow what regulation in UAE country. This one must will be we are follow تراخيص and municipality and what is right way. يعني sometime something in agreement not matching with what rule, what local rule for municipality.
Yes. So you mentioned TRACIS. TRACIS is the regulatory authority for buildings, including this building, isn't that right? And on the 14th of November, the same day of these events, You
Yes.
received an invitation, didn't you, to attend a meeting at Turkey's on the 17th of November. I can refer you to page 1286.
Yes, we go to Gazar with partner, we meet in Tarakhis and we respect. And after the decision come from Tarakhis, already we start smoothly handing over project to him.
Mr. So you agree that you attended that meeting, didn't you, on the 17th of November?
Yes, I go by myself to
Yeah.
Tarakhis. Yes, right.
And you received email on the 14th of November, which is at that page I just mentioned, on D1286. And you'll see Mr. Mustafa Resk in his witness statement at paragraph 133, which is at page 261.
Page 261.
You'll see paragraph 133.
Yes.
And at point C,
ABC. Okay.
about 3/4 the way down the page, halfway, a little bit over halfway in C, small c,
Yes.
Mr. Resk says that MESC attempted to prevent all subcontractors from working with Panther and took all steps possible to delay the building permit transfer to a new contractor. And he says, in this regard, I refer to the meeting which took place between Panther, Naga, MESC and Tarkis on the 17th of November 2019. Mr. Resk is suggesting here that your participation in that meeting was unhelpful.
No,
What
this
do you
is
say?
incorrect. This is incorrect.
What was your position as this contractor at that meeting, Mr. Al-Kurdi? Do you remember the meeting?
Of course, I remember meeting,
Yes.
and Tarakhis, he try make it as a he try let we join together again, we complete work. And that meeting, this Tarakhis engineer, he asked him, you will not find other contractor better from this contractor for complete your job. Take your time and thinking again, and let your previous contractor he complete your project. And will be never do anything wrong with any subcontractor, and will be what his decision, what final decision come by partner, and what Tarakhis will be instruction to us, we follow. But that meeting, what you ask me, what happened in the meeting, this Tarakhis engineer, he asked him, how many percentage your project complete? He say 90, we say 90, he say 85, like this. He say you cannot find other people. He will handing over a project better from them. Take your time and thinking again, and maybe you can find solution how you can work together.
What was the decision made? What decision did Tarkis make?
What decision we make it? We are waiting his partner. We are waiting him up to he take decision from his side, and
Yes.
he bring it a new contractor. We are
Yes.
waiting him. We cannot take decision alone. We
So,
are not waiting alone.
let me be clear, Mr. Al-Kurdi.
Yes.
Did Tarkis on the 17th of November, did they reach a decision about the transfer of the building permit?
Yes.
And what was the result of that?
We do. When will Tarakhis he tell to us handing over project to him, we start. Our project manager, he start with him one by one.
Yes, so you complied with the direction of Tarkis eventually, isn't that correct?
Which one not correct?
When Tarkis made the decision that the permit should be transferred, you complied with that. You respected it.
No, we follow Tarakhis regulation. He have two choice. He asked us, we and Mustafa Rizq is there. He tell him, if you want by accepted both party, we have some regulation. If both party not accepted, will be have other regulation. He asked us, we are accepted, we say no. Because we are not happy, we are not accepted with our client, we want to transfer to other contractor. He
Yes.
say, must you wait some time? We are follow regulation by government regulation, Tarakhis regulation. He give choice and we chose it. خلاص finish, no more.
Okay. So you said, you said, no, we don't agree.
Yes.
And as a result of, but nonetheless, Tarakhis,
Yes.
having heard both sides, directed that the building permit be transferred, despite your objection. Isn't that correct?
Not correct. We are follow Tarakhis instruction. We are respect local law and regulation. Tarakhis. When he give to us a new building permit for new company, we start handing over to him.
Okay, well, I think that's the answer to Mr.
Yes.
question.
Thank you, Justice Field. I think I've reached the end. I do have, I think, just one point that my client reminds me.
Yes.
That I think when you have been referring, Mr. Al-Kurdi, to an injury to one of the security people, that was not as a result of any action by any of my clients' staff members. I'm suggesting if there was a confrontation that was physical, it was between the two different security companies, and that my clients' personnel and staff were not implicated in that, were not involved. Do you agree with that?
Again, please, what happened between two security party? What's your question? I not hear you right way.
You mentioned that somebody went to hospital.
Yes, right. Our security
and
manager.
I'm asking you simply, do you agree or disagree that the person who caused that injury was not an employee of my client, was not a Panther security company person, I think?
No, who bring him to side, this guy?
Okay. I think your answer is that it was a security person who was brought there by my client. Is that correct?
Your client partner, he bring him to side, of course.
Okay. Thank you.
How he coming, Yani, by himself?
Is there anything else? Thank you very much, Mr. Al-Kurdi. Those are my questions.
Yes.
Mr. Barrow?
Yes, Your Honor, I'm slightly conscious of time, so I'm going to try and keep it as brief as I can.
Yes.
I think I've got 4 questions to ask, if that's permissible. Mr. Al-Kurdi, if you could just take you to page 1251.
1 minute, please. 151.
1251.
1251.
Well, actually, if you go to 1250, but you can scroll up from 1251.
1250.
Correct.
Okay.
You had taken to this letter earlier, Mr. Kurdi, and it's the letter that was sent by MESC on the 3rd of November in relation to the slowdown of work. And then if we go to the second page there, 1251.
Second page,
And you say here, in view of the above and considering continuation of the employer's failure, MESC has no other option than reducing the rate of work. Could you just explain what is the difference between reducing the rate of work and suspending the works?
We make as a slowdown. We are not suspension, never suspension work, but we are slow down. We make it. We allowed everybody, all subcontractor working only from our side. We let work go a little slow, for we understand what the plan for partner. Yani this one, always he say we are suspension work. We are not suspension work. We are slow, make slow rate down, because we try bring him again for we complete the project with him. This what difference between slow down? We put our team will be never leave the project. We are continue. Our employer come. Our labor come, our engineer, everybody there, but we care about what his plan, because he is not clear with us that time. After after 3 November, after his liquid damages guarantee, we not understand what he want honor, what his exactly plan, how we can move in this project. For
Okay,
this one.
Sorry, Mr. Cody, if you need to finish.
Yes.
Okay. Mr. Cody, in relation to this, say also in the second paragraph here, you say this correspondence shall constitute a notice of clause 16.1 of the conditions of contract. Now, I think may not be controversial for me to put this in a leading way. 16.1 is the suspension clause of the conditions of contract, isn't it?
Which clause?
16.1, the clause that's referenced here.
16 point. And this letter.
Yes. So, I'll put the question another way. You have confirmed within this letter that this letter is a notice pursuant to clause 16.1, haven't you?
Yes, Mr. Alexander. This clause 16.5, really, I not remember now. I want to go back to what 16.5, what's there in this clause in agreement, in contract.
That's all I wanted to clarify, Mr. Cody, in relation to this. Thank you. Mr. Cody, slightly related but separate point. You were giving evidence earlier in relation to what happened after termination, and in particular, you said the project was still under our responsibility.
Yes.
Because it hadn't been handed over and there wasn't a new building permit. So
yes.
Could you just clarify, why did you consider that even after the termination notice, you still couldn't give the possession of the site over? What was there any restrictions?
Okay, Mr. Alexander, here in UA regulation, if a client he termination agreement, but this not means he from second day he can enter to project and complete work, because will be this building permit under our name, insurance under our name, anybody, any damages, any accident, anything happen in a project is still under our name. He cannot continue. He cannot continue work and bring anybody from his side continue work under our name. Must he will bring a new contractor and put the project under his name, and he transfer everything to his name. That time he can continue. For this we say local regulation will be change contractor. If a client he want termination contractor, he can, but must by rule here, must he bring a new contractor and he take from authority permit, or he can enter and work. But as owner, as a client by himself, he cannot enter, because still our response for any accident, any damages, any happiness, anything happen will be under our responsibility. This is my opinion.
Okay, so thank you, Mr. Kurdi. So you were then asked questions about what happened, I think, on the 14th of November 2019, and a bus that went to site with MESC employees. Could I just clarify, were MESC employees still going on a bus to site every day during November until this time anyway, or was this just a one-off?
No, we send it our labor. We won't take our tools, our thing. We are not sending him for work. Our labor, if we want to use it, our labor in other site, he have tools. And these tools in the site, we send it our worker to site for take his tools and go out only. Okay.
Thank you, Mr. Kurdi. Finally, if I could just take you to page 284.
Page 284.
So this is your witness statement.
Yes.
So you were taken to paragraph 18, and you were referenced about the real estate grievance appeal. Now, I just wanted to clarify in relation to this. Now, I don't want you to disclose what the nature of that advice was, but did you receive any legal advice before this case was progressed? So you see the case there, real estate grievance appeal. Were you receiving legal advice in relation to that case?
Okay. This is.
I don't want to clarify, Mr. Kurdi. I don't want you to disclose what that advice was. I just wanted you to clarify: did you have any legal advice?
Legal advice?
Yes.
I won't say what his case, what he put it, this incorrect, only this.
Okay, so final question, and so I'm just something I want to, my solicitors wanted to raise. It's in relation to the labour point that we just discussed, so about sending the labour to the site. How would the labour ordinarily be sent to the site? By what mode of transport?
Our labour?
Your labour,
yes.
how would it ordinarily be transferred to the site? What mode of transport?
Transport by bus. Every day we take him by our company bus, okay. Transportation bus.
Thank you very much, Mr. Kurdi. Those are all the questions I have.
Thank you. Thank you very much, Mr. Al-Kurdi. That's the end of your evidence, and I release you as a witness.
Justice Field, I'm sorry to interrupt, Justice Field. There was just one aspect on the 16.1 that there's an amendment to that, but I can save that for a legal submission.
Yes.
Well, I'm sorry to interrupt.
That's quite all right. The transcript will note that you're reserving your position from a legal point of view in respect.
Thank you very much.
Yes. So, Mr. Al-Kurdi, thank you very much for coming to give your evidence. Your evidence is now complete. I release you as a witness. You may leave, or you may continue to observe through the virtual means which are available to your company. Thank you very much.
Thank you.
Now, we move then to the expert witnesses, and we've been going for an hour and a quarter. I think a 10-minute break, so that everything can be got ready, and we can just adjust ourselves to a very different sort of evidence that will be coming from the experts. It's 1:15 now, so we shall resume at 25 past the hour, and it'll be your main expert witness that goes first, won't it, Mr. Dillamale?
Yes, indeed, Mr.
Yeah.
Allen.
Mr. Allen.
Thank you.
Right. Thank you very much.
Thank you.
Alan, on the stand. Where are you, Mr. Allen? Are you in London, Scotland, Dubai?
I'm in Perthshire in Scotland.
You're in Perthshire. Very good. I'm sure you've given evidence on numerous occasions, but
Yes.
I have to tell you that in this court, all witnesses, including expert witnesses, give their evidence on oath. It can be a religious oath, it can be an affirmation. The court makes no distinction in terms of the value of a secular oath or a religious oath. What sort of oath would you like to take?
I can take a religious oath. I have a Bible with me.
Very well. Well, now, just hold the Bible in your right hand, if you would. Do you sincerely and solemnly swear that the opinions that you express in your report and the factual matters that you state in your report are in the first instance honestly held, and the factual matters you believe to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, Mr. Allen. Yes.
Well, I think subject to the court, there's no need for me to ask you to confirm again that these are your reports. There are two reports, one dated the 15th of July and one dated the 15th of August 2021. Is that correct?
That is correct, yes.
And they are your cumulative expert evidence on quantum and delay in these proceedings.
That's correct.
Yes. And is there anything that you wish to correct or clarify in those reports at this point?
No, there isn't.
No, thank you. And I think you're aware that Justice Field has allowed the experts in this case to give a presentation prior to being examined by the other side. And I understand that that's an option that you'd wish to take, yes?
Yes, I have a presentation here ready to present.
Thank you. And I think that is something that you've discussed with our team here, and we think you're able to share your slides but on your own system. We do have a backup.
Yes,
plan.
I would.
Yes.
Yeah, I was intending to share them through the Teams platform, if that's okay.
Is that okay with the court and
Well,
Mr. Burrell?
I'm a complete naif when it comes to technology, and I'm quite prepared to trust the judgment of others as to how this presentation is to be put forward. So I think we're just in the hands of Mr. Allen, and we'll see how we go.
Thank you. I wonder, for the ease of the court and of course of Mr. Burrell, we do have. Do we have a PDF ready to go, and we can send that by email, or it's? Oh, sorry, I'm told it's on case lines. Excuse me.
It's on case lines.
Right.
Oh, it will be.
It will be. All right.
Well, no, we need it to be available to the barrister on the other side. So maybe PDF it to. Yes. Excuse me. So that will be done immediately.
Yes. But in
Thank
the
you.
meantime, we can get on with the
Yes, indeed.
Yes, well, you go ahead, Mr. Allen.
Thank you very much. I'll try to share it now with the system. Sorry, I think the fact that I have the case line open is a memory issue. I'll just close that at the moment.
Okay.
Is the presentation visible to you now?
Well, I can see I have something in the middle of the screen, which tells me that this is your report, your expert report on matters of delay and quantum, and it's the presentation to the court for today. So I think
Yes.
I've got page 1, if you like.
Right. Okay. That's good. If you feel that it's somehow not visible, just at any point, just let me know.
Well, at the moment, it's all fine. Thanks.
Okay. Thank you. Thank you. So moving to the contents page, I'm going to fairly quickly, conscious of a 20-minute
Yes.
period, run through principally my findings and the differences between myself and Mr. Singhal on both delay and quantum.
Yes.
So as mentioned, the presentation summarises my findings based on the evidence available and addresses the area of disagreement. As you're aware, the commencement date of the project was 11th of July 2017. The time for completion was 16 months. Therefore, completion should have been by 10th of November 2018. However, the project suffered delays and the contract was terminated on 6th of November. The parties dispute the reasons for that and have each made their respective claims. Turning to delay. This slide 5 just summarises the respective positions of Mr. Singhal and myself. I've examined the 14 core events and consider that one gave rise to entitlement of potentially 74 days, which was delay event to late receipt of IFC drawings. Mr. Singhal's events are subsumed within 4 windows, and he considers that there are 306 days of excusable delays within those windows. Just an overview of the basis of my analysis. I've conducted my analysis based on the evidence available to me. In particular, I've studied the 4 extension of time submissions made by MESC during the currency of the project, and those submissions have been submitted as evidence. I conducted my analysis by considering the associated delay and the criticality of each claimed event compared with the contemporaneous programme updates. With the exception of one event, I found that the evidence did not support that any of the claim events were PANTHER culpable delays. As mentioned, I've established that one event did potentially give rise to entitlement, and that was a delay of 74 days. I've considered also the opinion of Mr. Singhal, but that hasn't led me to change my opinion.
Is the critical metric the impact on the impact on the critical path, if I can call it that? Is that the essential yardstick that marks your approach?
Yes, it's considering the impact on the critical path, because it would be the critical path impact that would give rise to an extension of time entitlement. So if events may cause delay, but if they're not on the critical path, then they wouldn't contribute to an overrun of the project. So my analysis has been with reference to the contemporaneous critical path, as evidenced by the updated programmes that were issued during the currency of the project.
Yes, I understand. Thank you very much. Do go on.
Thank you. Okay, thank you. Now, bullet point number 2, Mr. Singhal's principal analysis does not rely on any of the contemporaneous programme updates. rather only the baseline and a previously unseen as-built program with a data date of 7th of November. Mr. Singhals determined an alleged project critical path delay using, in his words, common sense and practical analysis, rather than the actual contemporaneous evidence, which was the program updates. In my view, Mr. Singhals' critical path is clearly wrong when compared with the available P6 format program updates post 30th of October 2018. Therefore, I believe that he's impacted the events to what is effectively the wrong critical path. Mr. Singhal adopts all delays within each of his 4 windows, then in my view makes the unsupported assumption that the critical delays within those windows must have been caused by the notified delay events. Mr. Singhal has introduced 10 new delay events which haven't previously been claimed or included in the pleadings, albeit he's made no analysis of those events. And he's also introduced a second form of analysis in his supplemental report. Now, Mr. Singhal was apparently provided copies of all of the defendants' contemporaneously updated programs in P6 format, which he used to prepare his so-called TIAs in his supplemental report. However, those P6 format files, which are essential for delay analysis, have still not been made available to me. I was only provided with a P6 copy of the program updates post 30th of October 2018, when in fact all of the delay events that are relied on took place before the 30th of October 2018. Mr. Singhals utilised the contemporaneous updates to interpolate the data to create a new updates with a data date closer to the start of the delay event. So that is to say that he's looked at the contemporaneous programs and he's tried to recreate an update within the in between where those programs fall, in order to make that, well, theoretically, in order to make it closer to the delay event. I wasn't able to check or verify the exercise that Mr. Singhal has carried out because there's no audit trail or explanation as to how he's created these new programs. For example, he's created his own program with a data date 26th of December 2017 in order to analyse delays associated with a change in the lift supplier. However, that program shows a completion date, a forecast completion date of the end of March 2019. But when I compared that with the contemporaneously available program updates of 16th of December and 2nd of January, they were showing 16th of December and 9th of February completion dates respectively. So there's no correlation between Mr. Singhal's updates and the project evidence. Mr. Singhal has also used that same program update 26th of June 2018 to impact the delays associated with those 6 referenced delay events. Now, once again, that's not a contemporaneous document. It's one that Mr. Singhal has created himself. And the other significant problem with this is that each of the events are some weeks or even months beyond the data date of that program. So I don't think that's a proper or realistic way of impacting the programs, because you're impacting events to a static program which precedes by some duration the actual time of the event. And this also might have the effect of concealing concurrent delays that might have been visible had the event been impacted with a contemporaneous program. In my view, Mr. Singhal has been selective in adopting his programs and project data, even when there's better evidence available, i.e. more relevant and reliable programs. Therefore, I can't take any confidence in his delay analysis. Within my report, I've considered the matter of compliance with Conditions of Contract Clause 20.1, which is the provision of notice of delay events and subsequent submission of claim particulars, which I found that MESC substantially hadn't met those requirements, but Mr. Singhal hasn't examined that within his report. Mr. Singhal's made certain criticisms of my report. I'm at slide 10 here. For example, he said that I've failed to provide a critical path analysis. In fact, I would say that Mr. Singhal has ignored the critical path himself because he hasn't used the contemporaneous programs. Rather, he's used his own common sense approach. He's also suggested that I haven't assessed the magnitude of the delays. Actually, I have considered each of the delay events in detail, albeit I found that only one had a potential critical path impact. And I performed an impacted as planned delay analysis on that event. Finally, bullet point 5 there. It remains even to this day impossible for me to conduct a full-time impact analysis for the core events that are relied on, because I'm still not in possession of the P6 native file, native format programs prior to October 2018. Those were neither provided in the document disclosure nor otherwise, but they were apparently made available to Mr. Singhal for his supplemental report, albeit he has not provided them as evidence as an attachment to his report. Turning to certain events where Mr. Singhal's raised criticisms, delay event 1, civil IFC drawings. Yeah, my analysis, I would say, is based on the contemporaneous programs, which clearly showed that the excavation work was extended, but the successor preparatory concrete works were on schedule, and there was no delay due to the Etisalat DU cable issue. Delay event 4, issue of post-tension drawings for the podium slab. The late approval there was driven by the late submission of the MESC drawings. Otherwise, the approval of the engineer was in good time. Delay event 5, post-tension drawings. Again, the late approval was driven by the late submission of the MESC drawings. Approval was in good time. The IFC drawings delay was 2.5 months, but the delay to these drawings was an extra month, so 3.5 months in total. Delay event 18, casting level 5 slab. This is a new event which was introduced by Mr. Singhal, as with 19, but he's made no analysis himself of that event. Delay event 8, finalization of the 12th floor structural design. Now, in my view, it was the delays caused by MESC's own post-tensioning subcontractor and the lack of reinforcing steel on site that in fact delayed the casting of the 12th floor slab. Within MESC's skeleton document, they've referred to a 133-day period within which MESC could submit their drawings for post-design approval. Now, if I've interpreted this correctly, I believe that period is between the approval of looking at the baseline program, between the approval of the shop drawing detail for floor 1 to floor 12 on the 11th of February 18 until the planned start of the casting of the 11th floor roof slab on 24th of June 18. But the difference between these dates is essentially a period of float. And in fact, that float was used up by MESC to the extent that they submitted the post-tension drawings for the 11th floor roof late. So I don't think there's any issue with this 133 days. Turning to delay event 12, the final architectural and structural layout for the roof. Again, I found that the delays were caused by MESC's own post-tensioning subcontractor in casting the roof slab. The roof slab casting delay and the 11th floor roof slab, as noted previously, were principally due to late submissions by MESC and its post-tensioning subcontractor. And just a note at the end, Mr. Singhal has presented that only one delay event to block work, whereas the table at paragraph 131 shows delays to block work at almost every level. Delay event 6, glass balustrade. I've reviewed the program here, and the delays are principally, in my view, being caused by non-payment of the subcontractor and not addressing the mock-up issues, also live and wind load issues in time. So, summary on the delay analysis. At the point of termination, MESC's extension of times applications 1 to 3 were the only documents available. In my view, neither those nor inclusive of 4 have demonstrated entitlement, with the exception of the one event for the IFC drawings. Mr. Singhal has not examined those extension of time submissions at all within his own report. I don't consider that Mr. Singhal has accurately identified the critical path and that he's effectively impacted the wrong critical path. And crucially for me, he hasn't relied on the contemporaneous program updates. Skipping on quickly to quantum. So just here summarising the respective assessments of myself and Mr. Singhal on the PANTHER claims. So it's principally, well, there's principally 6 items, but 4 of them are within the remit of Mr. Paul. So we have delay damages, damages for the cost of completion, damages for other loss and damage, and general damages. You can see my assessment figures on the right side. Mr. Singhal has found that, in his view, the evidence was so poor that he's been unable to assess any amounts there. And turning to the MESC claims, principally prolongation costs, unrecovered head office overhead costs, and loss of profit. I've assessed the prolongation costs, 229,000. The difference between myself and Mr. Singhal is not so great. My assessment there is premised on 110 days, whereas his is 316 days, I believe. The head office overheads and loss of profit, I've assessed at nil, albeit I've made calculations for the court. The value of works, we have a difference of opinion. Mr. Singhal principally relies on MESC's valuations, whereas from my perspective, I substantially rely on the engineer's post-termination valuation. I'll not go too deeply into the figures in the interest of time. Value of works, once again, it seems to me the MESC valuation, last valuation, claims 100% completion for some of the items, including prelims, which simply cannot be correct. And Mr. Singhal's also relied on weekly reports, etc., in order to justify completion of about 95% as of the point of termination. However, that actually conflicts with their own latest updated program, which was only showing about 81% completion at that time. I'll skip forward. variations, Mr. Singhal has a value of 2.3 million, but I think he hasn't taken into account the fact that the variation work was not complete. So the engineer had valued the variations at 1.7 million thereabouts, but that was forecast to completion. But it would appear that only about around 1 million dirhams worth of work was actually done at that point. Just noting at the bottom, Mr. Singhal's raised a concern that there's a double deduction for the emission of the VO6 kitchen cabinets. That was indeed the case within the engineer's valuation certificate 21, but that was corrected in the post-termination valuation. Delay damage is relatively straightforward. I'll not spend time on that. Cost of completion. There are certain criticisms that Mr. Singhal has made of my report within his supplemental report. I've endeavoured to address those within these slides. In blue, I've taken on board one of Mr. Singhal's criticism, and I make a negative adjustment to my report. That's relatively small, and as I say, we may come back to these items during this cross-examination. Similarly, he's made certain criticisms about the evidence, the existence of purchase orders, etc. Again, I've made one correction in blue. It's a negative omission, taking on board Mr. Singhal's comment. But if necessary, we can come back to those other items. And this is the adjustment I've made, 41,000, 23,000. I've also added 307,000. There was an item where I'd mistakenly excluded it from both the completion costs and the other damage heading, when in fact it should have remained within one of those headings. So I've added that back in. Loss and damage, yeah, this is the deduction, 23,000. I agree with Mr. Singhal's comments there. Prolongation costs, Mr. Singhal's conducted a 2-month audit in a 29-month period. I don't necessarily have a problem with that. It's normal when there's a large amount of data to do a sample. I conducted a similar sample review, and our findings are not dramatically different. Final items, unrecovered head office overheads. I've assessed this at nil, albeit I've made calculations. I don't consider that MESC have met the usual threshold conditions for establishing unrecovered head office overheads, which includes proving that they were unable to bid.
Oh, something's gone wrong. Mr. Allen, I'm afraid we lost you for about a minute.
Okay.
Well, you're back now. So whatever you said in the last minute, would you mind repeating?
Did you, on slide 30?
Yes, we were on slide 30.
Right. Okay. Very good. So just to finish off there, the unrecovered head office overheads, I've excluded that item on the basis that MESC haven't met, as I understand it, the usual threshold conditions to establish such a claim, which includes proving that they were unable to bid for other work due to resource constraints caused by this project. Loss of profit, I also consider that fails. Again, I've made the calculations. The definition of cost in the contract excludes profit and is limited to expenditure. And that concludes the presentation. Thank you.
Well, thank you very much, Mr. Allen.
Thank you, Mr. Allen. Could you please answer the questions of Mr. Burrell?
Certainly.
Yeah, sorry, you're right. I'm just going to be a couple of minutes.
Yes, of course.
Quite a lot of information within that.
Yes, yes. Do you want more than a couple of minutes?
1 moment. I think one. Potentially, if I could just have 5 minutes, Your Honour.
Yes.
If that's permissible. And so
Yeah.
I think that would bring us quite neatly to 11 o'clock.
Very good. Well, then we'll stand down for 5 minutes and we'll resume UK time at 11 o'clock.
Thank you very much.
Thank you.
Do we have Mr. Barrow?
Yes, Your Honour, here I am. Sorry.
Oh, good. No, not at all. Are you ready?
I think so. One moment. Do we have the presentation? Do we all have the PDF of the presentation? I think that was just sent by.
Yes, it's come by email to me via the registry.
I've got it as well. Okay, I'll be making reference to that.
Yeah.
At some stage. One moment. Okay, ready to go. Sorry, apologies. Thank you very much for the indulgence there. Mr. Allen. Ms. Allen, you've prepared 2 reports for this hearing, and you've given what you set out as your opinion on both quantum and delay. That's correct, isn't it?
Yes.
But it's right to say that in reality, you're really a quantum expert as opposed to a delay expert. Is that correct?
Yes, I'm principally a quantum expert. I mean, I have some many years of working with delay programs, but in this case, the principal delay analysis was done by my colleague, Mr. Dale Clark, with my input and oversight. But yes.
Okay, we'll come to that in a moment. It's right to say that you're a chartered surveyor, as I understand it, correct?
Yes.
And you're a RICS, a registered expert witness, correct? Isn't it?
That's correct.
Could we just go to your CV? So I think this is it's at page 2375. Do we have that?
Yes, I do.
Yeah, so we can see there at the top of that page, and indeed you can scroll down, it says at the top of the 2nd page and the 3rd page, Brian Allen, quantum expert, correct?
Yes, that's correct.
And then if you go to, I think it's, so it's the 2nd page of the experience summary, and it's the 2nd sentence, 2nd line. Brian is also a testifying quantum expert. So it says within your CV that you're a testifying quantum expert, but not a testifying delay expert. Is that correct?
That's correct. But you'll see elsewhere in my CV that I have experience with delay and disruption claims.
I've seen in your CV that you've been an expert in hearings as a quantum expert. I've not seen in your CV that you've been a testifying delay expert. Is that correct?
That is correct, yes.
But you're here today testifying as a delay expert as well, correct?
Yes, the preference was to have a single expert, so I was happy to take that on. But if it should be the case that there are questions of such a detail I can't answer for you straight away, I could refer to my colleague, Mr. Clark, and revert to the court if that was necessary.
Okay, well, that's an issue that we can deal with between the parties if necessary. Could we go to page 380? So this is your first report. And, sorry, one moment. If we go to paragraph 1.5.1, you state here, I've been assisted in the preparation of this report by Mr. Clark in matters of delay analysis, correct?
Yes.
And I think that's what you stated earlier. And if you go to the bottom of that paragraph, you say here, Mr. Clark has prepared the detailed delay analysis, correct?
Yes.
So it's right that actually in relation to the delay analysis, it's not a question of you preparing it and being assisted. It's Mr. Clark that's prepared it, correct?
He has principally prepared the report, but I'm conscious that I was the testifying expert, so I worked closely with him on that and in the review and analysis.
Okay, and finally on this, go to page 382, so just scroll down 2 pages. And paragraph 1.4.1. And it says here, the delay analysis has been undertaken by Mr. Clark. So I think that's consistent with what we've just been saying, isn't it?
Yes.
Now, I note that you said that there was a preference to have a single expert, but if Mr. Clark's a delay expert, why isn't he giving evidence today?
Well, he can't answer that question. That's not a question for him. It's a question for the decisions made by the legal team.
I understand, Your Honour. I'll leave it there. I think you understand the point. Well, let's do the best we can. If we go to, okay, moving into the actual nuts and bolts of this, if we go to 6163. So to clarify, this document is the SCL Delay and Disruption Protocol, 2nd edition, February 2017. And what I'm looking at is paragraph B there on 6163. And it says here, typically delay analysis requires the identification of the critical path to the completion date. Would you agree with what that says in relation to what a typical delay analysis would require?
Yes, I would.
And if we could just go to page 383. Well, 382 to 383. So just scanning over the pages. And we see there, it says in 1.4.2, the first one is, as these are your instructions, a review of the parties' respective claims. And then bullet point 2, a delay analysis to determine responsibility for delay, as well as consequences. So it's right that under your instructions, you were required, or Mr. Clark was required, to prepare a delay analysis, correct?
That's correct, yes.
And as we've just confirmed, under the SCL guidance, a delay analysis will typically require identification of the critical path, correct?
Yes.
It's right that in this case, neither yourself nor Mr. Clark has identified the critical path. Is that correct?
We don't have a single critical path running through the project. That was made impossible because the P6 contemporaneous native files weren't disclosed to us. So what we've done is we've looked at each delay event relative to the closest contemporaneous program update, albeit for most of the months we've had to do that looking at PDF files. But with reference to those, we have considered whether there appears to be any critical path impact caused by the events at that time, or whether it was other events, either concurrent events or predecessor events that were in fact driving the delays. So I would say we have done a critical path delay analysis, albeit our ability to do that was somewhat constrained by the fact that the P6 files were not released.
Okay, all right, well, let's explore that issue a little bit. In relation to the P6 files, these are necessary for what would be a PIA analysis, correct?
Well, they're necessary for any form of delay analysis. I think any delay analyst would like to see the P6 files because otherwise you're only looking at an image, a PDF image. So if you only have a PDF image, you can't see what the logic relationships are between the activities. You can only guess, but you can't see the lag. You can't see the successor, predecessor activities. You can't follow the critical path logic. You can't see the extent of float between activities. So you're very much constrained.
If you did have the P6 files, would you have done a TIA analysis? Is that what you're suggesting?
Yes.
Okay. Could I just take you to 1 second? Okay, and to clarify, a TIA analysis is a prospective method of analysis, isn't it?
Yes.
Okay, if we could just go to page 6163. So this is again the SEL, this delay and disruption protocol, and what I want to look at is subparagraph E here. And you can see here it says delay impact is determined in one of two ways. A prospective delay analysis identifies the likely impact of historical progress or delay event on a completion date, and the conclusions of a prospective delay analysis may not match the as-built program because the contractor's actual performance may well have been influenced by the effects of attempted acceleration. I think the important point I've got here is a retrospective delay analysis identifies the actual impact of the delay events on the defined or as-built path. Isn't it right that as the project had been completed, in fact, a retrospective delay analysis should have been carried out?
Well, I mean, you can debate the relative merits of the methodologies, but I think it's, in my experience anyway, it's well established that a contemporaneous type analysis is preferable. But unfortunately, our ability to do that was constrained. But in my view and Mr. Clark's view, the best evidence that we have of the critical path for the project was those contemporaneous programs which were submitted by MESC during the currency of the project. Now, Mr. Singhal has attempted to interpolate between the project data to recreate his own updated programs, but I don't see the need to do that when we have programs, albeit our ability to analyse them was constrained by the fact that we didn't have the native files. But I think the contemporaneous evidence that's available from the project is on a monthly basis is always the best, in my view.
Well, I suggest to you that that's actually incorrect. I suggest that if the project has been completed, a retrospective analysis is always going to be more reliable than a prospective analysis because you're relying upon all of the as-built data. Wouldn't you agree with that?
Well, you might do both analysis to compare the results, but I think the most reliable data we had was those contemporaneous programs, which is why we've used them. Now, Mr. Singhal has found it necessary to recreate his own programs. So I would say, even in the form of analysis that he's chosen, so I would say that would be a less reliable way of conducting the analysis.
Okay, well, I think Mr. Singhal couches his secondary analysis by stating that the TIA analysis is the one preferred by Mr. Clark in your first report. That's the reason why that was undertaken. In any event, he can be cross-examined on that at the relevant point. It's right to say, though, then, that Mr. Clark's analysis in this regard relies considerably upon the validity of the contemporaneous updated programs. Is that correct?
Well, that's correct. That's the best evidence that we have, and those documents were submitted as evidence in the case.
And there's also other contemporaneous data that could have been used as well, though, isn't there? Other letters and actually reviewing what the the physical evidence was in relation to it, rather than just the programs. Is that correct?
Yeah, of course, you can consider all forms of evidence, but in this case, the principal evidence was those programs, I would say.
Okay, well, we'll come to those programs in a moment. Would you agree that if those if the critical path within those programs were shown to be unreliable, would you agree that that would throw off almost the entirety of Mr. Clark's analysis?
Well, of course, you know that there's always going to be some errors within programs. That's the fact. But as I say, they have been submitted during the currency of the project. They've been submitted and relied upon by the defendant in this case. So I think it was right for us to consider those as evidence.
In relation to the analysis that Mr. Clark's undertaken here, in relation to which was what we've discussed, so looking at these specific events in a microcosm, as it were, and verifying whether they are on the programmed critical path or not. Would you agree that because Mr. Clark has not established a full critical path, he's not able to demonstrate what the actual delay events were? Would you agree with that?
No, I wouldn't agree with that, because he and I have been able to look at the programs that existed at the time of the event. So those were the programs that the contractor was working with. Those were the programs they were making the decisions with about criticality and about resources. So I think those were the appropriate programs to look at. Those were the programs that they had in their hand when they issued some of their delay notices.
Well, I'd suggest to you that because an independent critical path hasn't been established, neither you nor Mr. Clark are able to authoritatively confirm what the exact critical delay events were in this project. Would you agree with that?
No, I wouldn't entirely agree with that. I mean, we have determined the critical paths at the time the events existed. We would have liked to have done a detailed analysis with reference to the P6 programs, and if indeed there had been errors, they would have shown, if there's logic errors, for example, we would have been able to see those within the P6 files, but that opportunity wasn't available to us.
Okay, well, let's just concentrate on that point. You would have liked to have done some form of detailed analysis to establish the critical path. Is that correct?
Well, I think we've done a detailed analysis, but we didn't have the benefit of looking at the native P6 files. Okay,
but you accept that you didn't construct an entire critical path, and the reason why.
We know that. We know he accepts that, and he's explaining why.
So yes, Your Honour, I'm getting to the point. Isn't it right, though, that it is possible to conduct a delay analysis identifying a critical path without those P6 files?
It's possible, but it's certainly not. It's not desirable. I mean, as I say, we have to look at the evidence that we have. So we're dealing with a number of events, discrete events that took place at a certain point in time. So I think the best point at which to measure the impact of those events is relative to the programs that existed at that time.
You say it's not desirable. Isn't it, in fact, a well-recognized delay analysis technique to create a critical path not using those programs, in particular the as-planned and as-built technique?
Well, the as-built is retrospective. It doesn't necessarily show the critical path that existed at the time of the events. In fact, by simply looking at the as-built, you can get the entirely the wrong impression of the critical path, because the critical path will typically go through the longest or the last event, which may not have been critical throughout the currency of the project. So I would say it's quite unreliable simply to look at an as-built program.
So you're suggesting that any analysis ever done with an as-planned, as-built is always going to be unreliable?
I mean, typically in my experience, an as planned versus as built is only done in the absence of better data.
Well, in this case, you did have an absence of better data in relation to the P6 files, so why didn't you do this?
That was one constraint, but we did have the benefit of having most of the monthly updates, albeit they were only in PDF form.
It's right that as you haven't established a single critical path line, as it were, you're unable to confirm one way or another whether there was any concurrent delay. Would you agree with that?
The data that we had again was limited, so we didn't necessarily have visibility on concurrent delays, which was a problem.
Okay, well, we'll come back to the program updates in a moment. I just wanted to come on to some items that you mentioned within your presentation today. So if I could just go to, I think it's 5.1, so page 10 of the PowerPoint presentation.
Could you pause for a moment, please, because I've got to get this on another small screen to open. I've got to open the email. But
of course, please let me know whenever you've managed to get that
yes,
up.
I'll let you know. Yes. Which page was it, Mr. Barrow?
Page 10.
Page 10. Yes, I'm there now. Thank you.
Thank you. Mr. Allen, in your presentation this morning, you used the phrase in relation to Mr. Singhaal's report where he references common sense and practical analysis. You said Mr. Singhaal was using his own words, common sense and practical analysis. And then I think through your report at various other stages, you come back to Mr. Singhaal's use of the words common sense. Are you suggesting that this is the approach or the reference by Mr. Singhaal to using his common sense in this regard is somehow an unscientific and or unrecognized delay analysis technique?
Well, I'm not making a slight on the common sense of Mr. Singhaal, but the point is that he, in our view, has departed from the evidence. And he's created his own updated programs, and there's no audit trail that would allow us or anyone else to see the basis for those updates that he's created.
So I'll put the question again. Are you suggesting that using your common sense, specifically that wording, is not a recognized form of delay analysis technique?
Yeah, I'm suggesting that departing from the evidence is not, let's say, a sensible approach.
Well, no, I'm not suggesting departing from the evidence, but you have frequently used the phrase common sense within your presentation to suggest that it appears that Mr. Singhaal's approach is either unscientific or not a recognized approach. So are you suggesting that by Mr. Singhaal using his common sense, he's not adopting a recognized delay analysis technique?
I think I assume perhaps when Mr. Singhaal used that term, he was himself putting people on notice that he hadn't relied entirely on the project records or evidence, that he'd somehow interpolated the facts.
Okay, well, you're not quite answering the question here. Are you suggesting that it was that by the use of the word the phrase common sense, he has not used a recognized delay analysis technique. Is that yes or no?
I don't know. I don't know what was behind the exact phraseology. My take on it was simply that Mr. Singhal had departed from the evidence.
Okay, you don't know what was behind the phraseology. Okay, that's helpful.
Well, he actually didn't say that, he didn't say that absolutely precisely. My take on what the witness has said is that he has assumed that when common sense is referred to by Mr. Singhal, it is indicating that he has departed from what would otherwise be cogent and relevant evidence. But exactly what Mr. Singhal had in mind when he mentioned common sense in his own report is a matter perhaps for further exploration.
Yes, my understanding was the last bit of evidence there, that he doesn't know where the phrase common sense, where that phrase has come from. That was what I heard.
Well, we better ask Mr. Allen to add anything that he wants to. And Mr. Allen, I mustn't put a gloss on what your evidence has been. I've simply related what, having just heard it without looking at a transcript, the gist of what you were saying in respect of common sense. Is your position that you don't understand what was being referred to when Mr. Singhal referred to common sense, or did you make some assumptions as to what he was referring to?
Thank you, Your Honour. No, well, perhaps I made an assumption. My assumption was that he was indicating that he hadn't relied entirely on the contemporaneous programme updates, but in fact he had somehow interpolated the data to create a critical path that may not otherwise have been apparent from the evidence.
Okay, well, if I could take you to page 6166.
6166?
6166. Again, this is the SCL delay and disruption protocol. And now, certainly, I heard your evidence during your presentation this morning that Mr. Singhal was using his own words in relation to the common sense and practical analysis. If you look at subparagraph D and about the middle of that paragraph, it says here, the analyst determines the contemporaneous or actual critical path in each window by a common sense and practical analysis of the facts. So isn't it right that actually the wording that was used by Mr. Singhal is in direct reference to the exact type of delay analysis technique he was conducting?
Well, as I say, I'm not sure what exactly was Mr. Singhal's intention, but as I say, my understanding and taking his evidence as a whole was that he's departed somewhat from the bare facts and the evidence that can be seen within those programme updates.
Okay, well, I think point's been made. If we go to some of the more specific criticisms that are made in relation to Mr. Singhal's report, if we go to page 683. And we look here at paragraph 3.3.3, and you state here the activities shown within the table are, or Mr. Clark states here, shown within the table are summary activities. In the case of summary activities, material submittals and approvals are made up of several hundred. Now, so I think this is a regular criticism in relation to each of the windows that Mr. Clark makes, and the effect of it is that it's inappropriate to use a summary activity because there's actually hundreds of actual activities, and the actual durations are sometimes greater than what the summary durations suggest. Now, isn't it right that using the summary activities is a natural consequence of using the as-planned and as-built delay analysis method?
Well, I mean, the problem with summary or otherwise known as rolled up activities is that they don't necessarily represent a continuous activity. So you may have 30, 50 or more activities rolled up into a summary activity, but within those activities, the work or activities may not be continuous. For example, the first activity may be digging a trench, and then you wait. There's a delay of 3 months until concrete is poured. But if those activities are rolled up into a summary activity, the 3-month delay in between is not visible. So I think that's the concern of relying on rolled up summary activities.
That's not quite an answer to the question. The question is, isn't it a natural consequence of using an as-planned and as-built delay analysis technique that you use the summary activities?
No, I wouldn't say so. If you had a concern that there was too many activities had been rolled up into one bar, if you have access to the P6 files, you can expand that activity to see if it is continuous or not.
But as we stated earlier, if you're using as-planned and as-built, often you're not relying on the P6 files, so you wouldn't be able to do that. So isn't it right that when you're doing an as-planned and as-built, you would only really use the summary activities?
No, I wouldn't agree with that. You should be looking at the P6 files in both instances as well.
Okay, I'm going to come on to the programs now, and it's another regular criticism that Mr. Clark makes in relation to Mr. Singal's report. So we'll just look at an example of it. That page 685, 3.3.13. So it says here, Mr. Singal has determined that the path that during window 2, the critical path went through superstructure. However, a review of the contemporaneously updated programs shows the superstructure were no longer on the critical path at that time. And I think this is what we discussed earlier, and it's in essence it's the very foundation of Mr. Clark and your analysis in relation to delay, which is to compare the events as within the EOTs or as claimed by Mr. Singal with the critical path as per the planned programs. Is that correct?
Yes. Yes.
And as I think I asked the question briefly earlier, but we're on it now, so I'm going to put it briefly again. If the critical path within these updated programs is not reliable, would you agree that these criticisms drop away?
Well, as I say, ideally, we would have the opportunity to investigate the reliability of the programs by looking at the P6 files. But of course, that wasn't possible. I mean, the second issue here about where the critical path falls, as I mentioned, if you look at an as-built program, you typically, the critical path looking backwards is different from the one that existed whilst the project was being constructed. So I think that's why you would always prefer to rely on, or at least use both in tandem, if at all possible, to establish the critical path.
Are you aware that the updated programs prospective dates, the critical path in relation to the prospective dates in these updated programs was never adjusted with the actual data? Are you aware of that?
Well, as I say, we don't have any insight to the data. All we know is that the programs were submitted as evidence, or they were submitted during the currency of the project to convince the engineer and the employer to award extensions of time, and they've also been submitted as evidence in this case. Now, whether there are elements of those programs that haven't been properly updated or not, I'm not aware that that's been disclosed by MESC to date.
Now, I understand that it's relatively common process on a construction site that when you're providing these updated programs, I think due to time more than anything else, it's very commonplace that the logic links for the prospective dates are not updated with the as-built data. Is that correct?
I wouldn't say it's correct. I mean, obviously, it's bad practice. It depends on the project, the competency of the planners, etc. But I wouldn't say that's certainly not an aspiration.
Okay, well, I suggest to you that is what happened in this case, and as a result, the logic links and the prospective dates in these programs are not reliable. I think I've put that to you before, and you're unable to comment. It is right, though, that Mr. Clark did encounter some issues with the accuracies of these programs. That's correct, isn't it?
Well, as with any program, there's probably a number of conflicts might arise, but yeah.
If we go to page 456 and look at paragraph 5.2.123. Apologies, I think 455.
Is that the page or the?
The page is 455.
Okay, thank you. Sorry.
One moment.
I'm sorry to interrupt. Can I just ask the page number again, please?
I think actually I'm not on the right one. It's I need to get to 5.2.163. Apologies. Let me just find the. I think it might be 1 second. It's 467. Apologies, not 456. 467. So you can see there, this is the first report, 5.2.163. It says here, the above screenshot shows a lack of credibility of MESC's updating of the program, as all of the kitchen-related submittals, approvals, and installations have not been completed on the same day. I'm just going to go to a couple more of these before I put the question to you. And these are just a sample. 476, I think, is the next page. And it's, yeah, paragraph 1.8, so 5.2.186. And you can see here at the very bottom of this paragraph, this suggests that the status for this activity was incorrect. I'll let you have a quick review of that one before I come to the next example. Okay, the next example is on page 479. And paragraphs 5.2.194. And the example that I want to point to is in the middle of it there. It says, therefore, in this instance, either MESC's allegation of late approval delaying the program completion date is wrong, or the schedule update is wrong. So it's right that Mr. Clark himself found various examples of issues with reliability of these programs for prospective dates. Is that correct?
Yes, there was a number of obvious errors that we did pick up and try to work around, yes.
Given the identification of these errors and the fact that you didn't have the P6 files, why didn't you think it was prudent to undertake an as-planned and as-built method?
Well, I mean, we saw the level of errors in these multiple programs. We tried to identify them and work around them, but you know, our level of confidence in the as-built program wouldn't be any greater. Perhaps we'd have even lower confidence in the as-built program because that's been created retrospectively and not at the time. So I certainly wouldn't ditch the contemporaneous programs in favour of an as-built program that's been prepared retrospectively. That's, if anything, that's likely to be less reliable.
Okay, I'm going to move on now. I'll explore the individual events that I'm going to be focusing on shortly, but I just wanted to ask you a few general questions now. Firstly, there's a series of questions about the IFC drawings, and then there's a few other general questions. It's right that in your, I think it's identified within your presentation, Mr. Clark assigned 74 days of critical delay to civil IFC drawings. That's correct, isn't it?
Yes.
But then within the second report, and I think we can go, if we go to page 684. And then paragraph 3.3.5, you say it's quite possible that the late IFC did not delay the excavation. So there appears to be a contradiction because there's a reference to there being critical delay as a result of the civil IFC, but then it's not causing critical delay to the substructure. Is that correct?
Yeah, I think the difficulty was that there wasn't full visibility on the concurrent activities, but you know, we could see the 74-day delay, but we can't say with certainty that there weren't concurrent MESC delays.
And sticking with the IFC, it's accepted, isn't it, that these were over 3 months late from the early start date, correct?
I think, well, 74 days was the impact. I don't recall the detail otherwise, but.
Okay. Would you agree that before the IFC are received, very little progress could be made on the project? Would you agree with that?
Yes.
And would you agree that whilst the IFCs may not have had the 74-day effect on the substructure works, it would have had a knock-on effect in relation to other activities on the project?
Well, I mean, any delay can impact subsequent events subject to the dependencies and, of course, the duty to mitigate. But yes, of course.
Finally, in relation to the IFC, if we just go to page 431, if you can scan over 431 to 432, and looking at paragraph 5.2.35, and in particular, I'm looking at 432, and you say here, I've determined that due to delay event 1, they would have been entitled to 62 days, but without any updates showing progress or lack of progress, I would recommend extension be without prolongation costs, correct?
Yes.
So is this because of the possibility of concurrency?
Yes, because again, as you pointed out yourself, the programs are not in absolute detail, and there are some errors. But yeah, we can't see the progress on all of the potentially concurrent activities. So
because there's just a possible concurrency, although not established, it's recommended that there's an entitlement to EOT, but not prolongation.
Yes, there may well be other activities which were delayed concurrently.
But isn't it right that under the contract there's no entitlement to EOT if there is concurrency?
I don't recall if that's the case or not, but the common practice in the event of concurrent delays would be time and no cost.
Okay, I think it is actually, well, I think it's referenced earlier in your report. One moment. Okay, well, you've copied the clause, but it might be that it's not in your mind right now. It's for the benefit of the tribunal, it's or of the court. It's at 5.2.14 where the conditions set out. But so wouldn't it be right to say that actually there is an entitlement to EOT and prolongation, or it's neither?
Sorry, can you just refer me to the particular clause?
Okay, it's at 5.2.14 of your report. So. I think it was anyway, 1 second.
Yeah, I see the clause there at 5.2.
Yeah,
14. I mean,
page 46.
Yes, the wording is rather vague, but I suppose it could be construed from a legal perspective to exclude entitlement to time if there was perceived to be concurrent delays, but that would be a legal argument, I would think.
Okay. Well, I mean, it's obviously not in my client's interest, but it is a clause of the contract, which I'm sure the other side, or Panther, will be making submissions on. All right, we'll move on. The point is that you hadn't clocked in relation to this clause the fact that if there is concurrency, there's no extension.
Well, I thought the clause was sufficiently vague that it wasn't clear enough for me to say that was the intention of it. So that wouldn't be, in my view, an equitable solution. But as you say, that's subject to legal opinion.
Well, you say it's vague, and I'm arguing the contrary point here, but you say it's vague. It says that the final line here, under no circumstances shall the contractor be entitled to an extension of time in respect of any concurrent delay. It's not vague, is it?
Well, it's the wording in respect to any concurrent delay. I think if the intention was to exclude entitlement if there are concurrent delays, it should have said that to an extension of time if there are concurrent delays. But it seems to be alluding to an extension for the concurrent delays, which is confusing.
I understand. I'm moving off the point, Mr. Malone. I know the issue.
All right, I won't say anything then.
If we go to page 685, apologies, sir. I think I've discussed this point already. I think we can leave that. Okay. All right, let's get to window 1. If we could go to page 684. And it says here, substructure, concrete activities, IDs performed as planned, and then success IDs. So I think the point being made here is that because of the blockwork installation, dead shutter, that this was the delay as opposed to the IFC delay. So it was it's because of this this item that there was 5 days of extra delay, correct? So I'll let you review it so you can reacquaint.
Can you tell me which paragraph in the report where?
Sorry, apologies, 3.3.7.
3.3.7, thank you.
Yeah, so, sorry, what was the question?
So what the finding was here is that it was the dead shutter, the blockwork installation dead shutter, which caused the critical delay in the substructure works of the 5 or the 7 days, or 5 days, sorry, because it took 7 days to complete as opposed to 2, correct?
I believe so, yes.
I might need to get you to expand because these programs I've got quite a small writing, but if I could get you to expand the case lines page, unless it is already on the screen, because I want to look at the program under 3.3.8. Are you able to read the individual characters in that program?
Yes, I can, yes.
Okay, so I wanted to firstly just highlight, so there's 2 parts to substructure works. There's earthwork and there's concrete foundation, correct?
Yes.
In relation to earthwork, it says the original duration's 34 days, the actual duration's 49 days, correct?
Yes.
And then for the concrete foundation, it says the original duration's 28 days and the actual duration was 30 days, correct?
Yes.
And you can see here in relation to the planned start dates and planned finish dates, what was originally planned was that the concrete foundation would start as soon as the earthworks had all finished, correct? So 13th of November.
Yes, it appears that way, yes.
And so actually what happened in this case is you can see that the actual start date of the earthworks commenced before, so you can see in the start and finish, the substructure works didn't finish until the 30th of November. The concrete foundation started on the 13th of November, so it started 17 days early, correct?
Yes.
And as a result of that, and you can see in relation to the blockwork installation, so the blockwork installation started on the 16th of November. And at that time, there were still activities ongoing in the earthworks, correct? So at that time, there was still activities going on, I think, from dispose and cart away excavated material and compact the excavated area, and then the road base and soil improvement. So all of those were still ongoing at the time of the blockwork installation, correct?
Yes, it appears so.
Wouldn't you agree that the fact that all of those activities were ongoing at the time that the blockwork installation was ongoing would disrupt the blockwork installation activities?
Well, not necessarily. It depends on the nature of the activities. Compact excavated area, I mean, that could be in a different area from where the blockwork was situated. Road base and soil improvement, I mean, again, it could be remote. We might be in the situation of having rolled up activity bars here also, so it's difficult to tell just simply looking at.
I suggest to you that, okay, sorry, I know your point, but I suggest to you on a macro level, just looking at it on a slightly more macro level, you can see clearly in these substructure works, it's the earthworks that have been delayed, because they've been delayed by over 15 days, or exactly 15 days, whereas the concrete foundation work were only delayed by 2. So you can see it's the substructure works that are causing the delay. Wouldn't you agree with that?
Well, again, you know, without going into the detail, I couldn't say definitively just looking at this program.
Okay. All right, well, let's move on. Take you to, so I'm going to go to window 2 now, and page 685. And on page 685, I'm looking at paragraph 3.3.11. And you state here, you reference the internal finishes and MEP works. And so this is in your second report, and it's a criticism of Mr. Singhald's report, because it says the internal finishes and MEP works started on the 20th of December 17, but that couldn't be the case because the substructure concrete works were still in progress during this month. So the MEP works couldn't have been in progress. So it's an error that you're identifying, correct?
Okay, yes.
It says at the bottom, this error skews the results of the table. Now, as far as you can recall, though, isn't it right that Mr. Singhald doesn't identify MEP works as being on the critical path?
Yes, that's did seem somewhat surprising, but I think he considered that the balustrades were principally on the critical path for the latter part of the project.
Well, the balustrades were in window 4. Here we're concerned with superstructure works, so it's a bit earlier, isn't it?
Yes.
And here in relation to this window, he suggests that the superstructure works were the critical path, and in fact, as appears to be suggested by, I assume, Mr. Clark here, that indeed it's correct because the internal finishes couldn't be, the MEP works couldn't be ongoing at this stage, because the concrete was still being poured. So it sort of supports Mr. Singh's critical path, doesn't it?
Sorry, I didn't follow that logic, I must admit.
Okay, well, wouldn't you agree that if, as Mr. Singhal has not identified MEP works as being on the critical path, the commencement date of the MEP works would therefore not affect Mr. Singhal's conclusion on the critical path? Would you agree with that?
Well, on his analysis, if he doesn't find MEP to be on the critical path, then that would be the case.
Have you reviewed all of the? Sorry, have you reviewed the program updates or most of the program updates in this case, the ones we've previously discussed?
Yes, the ones that are referenced in the report.
And well, I'm not going to take you to one, but if I'm incorrect on this, Mr. Dylan Malone can correct me. But it's right that, or I'm going to confirm to you that actually the MEP works on all of these programs are confirmed to start on the 20th of December. And so that's why Mr. Singhal has put this date in his report. And so actually that's the only evidence of when these works would have started. So it's actually not necessarily an error. Would you agree with that?
Well, I'd need to look at the programs in question I can't confirm the dates off the top of my head.
No, I understand that. But if you assume that all of the updated programs do have MEP works as being on the 20th of December, then actually Mr. Singhal's report is not incorrect here.
I mean, the critical path for the project changes at various times. So it just depends on the scope of work remaining, concurrency, etc. It's dynamic, which is why, again, you wouldn't want to rely simply on an as-built program. So just because you see a critical path one month, it doesn't mean it will be the same the next month.
We'll move on to delay event 4. So I think we need to go to, it's also part of the second report, paragraph 3.4.5, and it was in your presentation this morning. It's on page 693. So sorry, when I'm referencing, sorry, for the benefit of yourself and the court, when I'm referencing delay events or delay event numbers, it's the numbers that have been attributed to these events by Mr. Singhal, because I know that there's 3 different sets of numbers. So it's the delay events as defined by Mr. Singhal. And so I'm talking about delay event 4, which is the issuance of the post-tension drawings for the podium slab. Now, I think the point that you make here is that within your first report, you demonstrated that the delays were caused by MESC's late submittals and not late approvals, correct?
Yes.
And it's right that the submission in this case was on the 25th of December 2017, when it should have been on the 5th of November 2017. Is that right?
Sorry, I'm not sure I'm at the correct page in the report. Could you?
Yeah, sorry. Instead of throwing figures at you, I'll take you to your first report, where this is identified. And so I think it's on page 434. And so it says here, paragraph 5.2.45. And it says here the submission date was planned to start and complete on the 21st of October and 5th of November. The submission did not actually start until the 25th of December, correct?
Yes.
It's right that MESC would need the IFC drawings to do their post-tensioning drawings, wouldn't they?
I would assume so. Again, I'd need to look at the details. Yeah, I don't know. I haven't seen reference to that, a direct link to between the drawings, but
how could you do the post-tensioning drawings without the civil IFC? Surely they're an absolute necessity.
Well, the post-tensioning is a very specialist. Well, it's usually done by specialist subcontractors, so it may be that this was more of the nature of a working drawing, which is often produced by specialist subcontractors. But I'm not certain that that is the case, but it may be the case. Okay.
Well, I suggest to you that it is an absolute necessity to have civil IFC drawings before you do the post-tensioning drawings. But I think we've got your evidence on that. If it is the case, and if it is correct that you need to have civil IFC drawings before you can do the post-tensioning drawings, wouldn't you agree that it would be a bit unreasonable to have expected MESC to have produced these on the 5th of November when the civil IFC drawings weren't provided until the middle of October?
Well, if there was a direct link between the two, that would seem a reasonable conclusion, but I can't at the moment confirm that that's the case or not.
If there is a direct link and the IFC were delayed by 62 days or 74 days, as you've suggested, wouldn't that push the date for submission of these drawings back by the same respective period?
If there was a link between the two, but I don't think that has been. If there is such a link, I don't think that's been set out in any of the claim submissions or otherwise.
Okay, let's just go a little bit into the background of this. If we can go to page 5216. So this is Annexure 4 of Mr. Singhal's first report. Now, I appreciate that you probably can't confirm the verifiability of all of the events within this, but I'm going to ask you to assume, just for the purposes of this evidence, that they are correct. So we can see here in the paragraph 25, the approved civil defence drawing was received by the defendant on the 23rd of November, and then we can see here within December that there is a bit of a back and forth between the defendant and the engineer in relation to the podium height required. So there's a need for confirmation of the slab height for the podium, and then there's discussion about what's needed in relation to all these firefighter sprinklers, which actually isn't then later confirmed until 20th of December in relation to the parking area. So you can see that there's a variety of reasons as to why these drawings would be delayed. Would you agree with that?
Well, there's certainly a chronology, an exchange there, but I don't know what's been the trigger for that chain of activity. There may have been other delays before the first bullet point there.
But because you haven't, or Mr. Clark hasn't undertaken any specific analysis establishing one single critical path, you're unable to confirm one way or another. Is that correct?
Well, we've critically examined the 4 extension of time claims that were submitted during the currency of the project and as evidence in this case. So we've relied on that as evidence. We've and any other evidence we can find from the document production, etc. But there may be other documents we haven't seen that might have an influence on the analysis, but we can only go on what's in front of us.
I understand. Okay, if we go to paragraph, sorry, I've only got the paragraph reference. Apologies, let me get page reference. So it's paragraph 3.3.16 of your second report. And if I can just try and get, so it is page 686. And if we look at paragraph 3.3.16, you can see here it says So this is in relation to delay event 5 that I'm discussing. So this is the post-tensioning drawings for the typical floor slab. So delay event 4 was the PT drawings for podium. These are the PT drawings for the typical floor slab. And the point, I think there's 2 points that are made in relation to this in these respective paragraphs. So the first point is that your initial report demonstrated that the delay was due to MESC's late submittal as opposed to any late approval. In relation to that point, and we'll come back to the next paragraph on this, but we'll deal with that point first. You just go to page 5555. And we can see here that the typical structural drawings were actually sent on the 26th of February, weren't they? So this is a letter, sorry, from MESC to NAGA in relation to this event.
Can you help me with where I see? Oh, I see. It's the first bullet point.
Sorry, yeah, apologies. Yes, sorry,
Yeah.
First bullet point.
Yeah.
So they were sent on the 26th of February, correct?
Okay, that's what it says, yes.
Okay. All right. Well, whether that is late or not can be the subject of closing submission with reference to the plan durations. The other criticism is I'll go back at some. So go back to what is it? 686. Apologies, not 686. It's paragraph 3.3.16, which was 6.8. Oh, it is 686. So 3.3.17 I want to look at now. And this is the second criticism that's raised in relation to Mr. Singh's analysis of this event. And the point being made here is that, okay, well, even if there is delay of one form or another, actually the late approval or the late submission, whichever it is, didn't delay the superstructure works because, as you can see at the bottom of this paragraph, it says here, the first floor structural works started on the 29th of March and were completed in 10 days, so 1 day earlier than planned. So the point being that how could these have caused delay when the first floor structural works were still effectively on time, correct?
Yes.
But isn't it right that the structural drawings for certain floors would differ? So the structural floors drawings for the first floor would differ to the structural drawings for other floors?
Yes, I'm sure they would, yes.
And so if the structural drawings for the first floor differ to the others, just because the first floor has been able to be constructed as planned, that doesn't mean that all of the drawings for the other floors could have been completed and the other floors couldn't be completed as planned. Would you agree with that?
Well, I mean, I don't know the status of for the other floors. Of course, there'll be some common details to all of the floors, but just because one floor is able to proceed doesn't necessarily mean that the others can. I would agree.
Okay, thank you. Right, I'm going to move on to delay event 8 now, and this is dealt with, and this is on page 687, paragraph 3.3.20. And so we're still in the superstructure works here, and this concerns, sorry, 1 second. So yeah, this concerns the delay in finalization of the 12th floor structural design. I think I'm dealing with just with delay event 8 at the moment. And I think Mr. Singh stated that I think the combined events led to 99 days of delay in relation to the superstructure works. Just to clarify, within your second report, you don't address delay event 12 in relation to the superstructure works. I know you deal with it later on within window 3, and the block work, but you don't actually directly address delay event 12 in relation to the superstructure works. Is that correct?
In the second report?
In the second report, correct.
I don't recall, I must say. Perhaps has it been dealt with in my first report?
Well, my question is, it's not been dealt with in your second report.
Yeah, I mean, we wouldn't obviously replicate everything that was in the first report in the second report, but...
I mean, within your second report, you have generally gone through all of the main delay events that are referenced by Mr. Singhal in each of the windows. I think this is the main exception. So I just wanted to clarify that.
It may be that there was nothing new to respond to within the second report, so our findings remained as per the first report.
Okay. Well, in relation to delay event 8, so I think at 3.3.21, the point being made here is that, as I think it's both of these paragraphs as 2.1 and 2.2, and you say here that the design details were finalized on the 9th of August. And so, and then the formwork was completed on the 29th, and then within paragraph 3.3.22, there is a lot of reference here to the back and forth between MESC and its PT subcontractor and trackies for the approvals. And in essence, the point that I understand from the comments that's made here is that, well, actually, once the approval was given, it's not really Panther's fault as to why there was then a subsequent delay over this period, correct?
Yes, I mean, I think there was delays in this case due to the post-tensioning subcontractor issues and the lack of reinforcing steel availability. So those were the principal delays, which affected the casting of the slab.
So the lack of steel is I think you note that in relation to this 10 days, so that it would require 10 days to complete the slab because there was no steel. But wouldn't it be right that actually you wouldn't know how much steel you'd need until the drawings are finalised?
Well, that'd be a logical conclusion that if the delivery of the steel relied on certain drawings which weren't available, but I haven't seen that particular chronology, but.
Okay, and in relation to this, so all of these items, as I see it, and correct me if I'm wrong on this, as I see it, all of these sort of back and forth issues, they occur between the 19th of September and the 24th of October. Well, apologies, we'll push that forward until the 3rd or 4th of November for the 10 days to get the steel. So that's a period of about a month and 15 days, so about 45 days, correct?
Okay, yes.
So if we let's just leave aside that 45 days, there's still a delay for the remainder of the 99 days that are referenced by Mr. Singhal, correct?
Yeah, I'm not looking at the program, but okay.
Okay, and a slightly separate but related point, and it was one that popped up in your presentation this morning. But it's right that there was 133 days between receipt of the IFC drawings until the 12th floor blade slab had to be finalised, correct?
It would appear so, yes.
And 133 days from the finalisation of the 12th floor structural design, which happened on the 9th of August. 133 days from that would be the 20th of December, correct?
Okay, yes.
And actually, as we can see here, the 12th floor slab was cast on the 8th of November. So they did it within a lower period of time than the baseline had originally provided. Is that correct?
Well, I don't think that's the right way to characterise it. I mean, the 133-day period is effectively a period of float. So it's not, let's say, an entitlement that the contractor has to maintain that 133 days. In fact, the contract actually says that the employer owns the float, clause 8.3, but I mean, I don't think we need to go into that kind of discussion. So no, I wouldn't agree that the 133 days is a period that can be maintained. It just so happened that the programme had scheduled that activity to complete early, and the float means that the activity could have been continued. It could have been later by up to 133 days, but it's not a period of, let's say, entitlement. It will disappear in subsequent programme updates.
You would need quite a lot of time between when the drawings are finally approved to actually casting the slab. Wouldn't you agree with that? Because it's got to go through this tracky process, and it's got to go through, there's got to be a period of time in which all of these activities are to be completed. Wouldn't you agree with that?
Yes, I mean, it depends on the activities that are, we can only go on the activities that are shown in the programme. So the duration between those activities, again, looking at the PDFs, appears to be simply a period of float. There's no critical logic between the activities.
Okay, well, if Mr. Dylan Malone wants to address the float with Mr. Singal, I'll let him leave that issue to him. Now let's move on to window 3. There's only one event in this, but there's only 2 events left to go through in relation to the delay. One will be relieved to hear. So in relation to window 3, this concerns delay event 12, and I think the main criticism is made at 3.3.28. So that's page 688, 3.3.28. And the point being made here is that the approval of the roof blockwork shop drawings on the 27th of December, so they were approved then. It then took 42 days to start the blockwork on the 7th of February. And then I think the other point is that once the blockwork had started on the 7th of February, it then took more than 2 months to complete a planned 4-day activity. So the suggestion is even after the approval, there was still a delay to getting the shop drawings in, and even once, there was still a delay until the start of the block work, and then even when the block work started, it took a lot longer than it should have done. If I could just take you to page 585. So this is Mr. Singal's first report. I'll wait until you're there.
Okay.
Okay, and I appreciate we're not within the program on this. And again, Mr. Dylan Malone wants to take us to that another stage, then so be it. But what we have here is I'm going to ask you to assume that the planned dates in here are correct. And we can see here that the planned approval date for the blockwork and plaster was on the 13th of August 2018, and then the completion of the blockwork in the roof was to be by the 13th of August 2018, correct?
Sorry, I don't see the approval 13th of August. Where is that?
Oh, sorry. The approval of the blockwork is on the 13th of May, and the completion of the blockwork is on the 13th of August. Apologies.
Well, I'm looking at 138, the table.
The table, yeah.
Is that what we should all be looking at, the table in 138?
Yes, sorry if I hadn't clarified that. Yes, yeah. Looking at the table on page, under paragraph 138, if you can see the third item under the table, and you can see there it says plan date 13th of May, and then the final item, completion of blockwork in roof, 13th of August.
Yes, I can see that.
Now that's, I think that's a period of 92 days. Now, in reality, when we looked at your at the report earlier, and we can go back to it if you need. In reality, this period took from the 27th of December until the 15th of April. Now that's a period of 109 days. So, and I think Mr. Singhal does reference that there's a remaining period of 17 days in paragraph 140. So I think Mr. Singhal attributes those 17 days to MESC, but it's right that the other 92 days, for the other 92 days, this proceeded as would have been planned. Is that right?
I can't say if it's as planned without looking at the programs, but
okay. Well, as I say, I'm only on this table now, and I'm asking you to assume that the planned dates here are correct, as opposed to going to the baseline itself on this. And if I'm incorrect on that, again, I will be corrected. But if we assume that the planned dates are correct, 13th of May and then 13th of August, that's 92 days. So actually, MESC only delayed their completion of the block work in this regard by 17 days. If that is all correct, would you agree with me?
I can't readily reach that conclusion, but on our analysis, the activities were mainly being driven by the MESC submissions and in relation to the post-tensioning subcontractor. And Mr. Singhal's noted one delay event in relation to the block work, but there are multiple areas of the block work were delayed for unexplained reasons. So it seemed that there was at very least extensive concurrent delays to these activities.
But you are not able to establish the concurrent delays because you've not done a comprehensive delay analysis. Is that right?
Well, we're able to identify some of the events, such as the concurrent delays in the block work, and I think we have mentioned some of the concurrent activities and the predecessor activities, such as the post-tensioning subcontractor issue. So to the extent possible, we've identified what activities were going on at the same time. And
okay. Sorry, I interrupted you there.
Sorry, yes. So just to say, it would appear that there were concurrent MESC culpable activities concurrent with at this time. Okay.
All right. Finally, we're going to move on to window 4 and the final delay event, which is the aluminium balustrade. So if you go to page 689. So I think Mr. Clark makes a number of different criticisms here. The first one is paragraph 3.3.31, and it talks about the electrical works being electrical works date being incorrect because it's the 20th of December. I think we've already discussed that point in relation to another window, but it's the same issue in relation to this being the only actual event within all of the updated programs. So that's the only possible evidence as to when these events started. But again, it's Mr. Singhal's point that the electrical works are not on the critical path, therefore it wouldn't skew the results. Do you have, I mean, we've discussed that before. Do you have any further comment in relation to that?
No further comment, but you know, my report found that the balustrade work was not on the critical path.
Okay, yeah, we'll come to that in a moment. So the next one is 3.3.34. Criticism is made of Mr. Singhal that he selected the top 5 items based on planned budgets, but just because an item has a high budgeted cost does not necessarily mean it would be more critical than an item of a lesser budgeted cost. So I think the point being, well, just because there's higher budgeted items doesn't mean that they're more critical. Would you agree that the amount of a budget does have an influence in relation to whether it would be critical or not?
Well, only to the extent of volume of work. I mean, typically critical path goes through substructure, superstructure, MEP, which is the big ticket items. So to that extent, I would agree that if you look at the largest value packages in any construction project, the critical path probably goes through them. But I wouldn't say, generally speaking, that balustrades in a high-rise building would be expected to be on the critical path.
Okay, but you do accept though then that the largest packages, so the level of budget is a relevant factor to consider in relation to, I'm not saying the sole, but it's a relevant factor to consider in relation to the establishment of the critical path.
Only to the extent that it's indicative of the volume of work, but that probably doesn't apply in relation to the balustrades.
Okay, well, moving on. Sorry. In relation to this point, sorry, if we go to page 588. And we have here, this is Mr. Singh's report in relation to this issue. And we can see what we're discussing here in relation to why these 5 items that have been plucked out. And we can see what Mr. Singh says is actually, I selected 5 items with the highest planned budget and estimated remaining duration. So it's right that actually it's not just the planned budget that Mr. Singh has identified, he's also identified the remaining duration, correct?
Yes, I see that.
Okay, and in relation to this, so just as a very minor point, just in relation to the remaining duration, so we can see, for example, and I know there's a logic behind it, but you can see in item 14, paint. So obviously paint has one of the largest percentages remaining, but it's clear that paint wouldn't be on the critical path in this regard. Would you agree with that?
Well, again, I think it's very unlikely that painting would be on the critical path unless the whole of the decoration remained incomplete. But
okay, thank you. One moment. Whilst we're just on this, sorry, 1 second. Okay, there's another comment was made in relation to in your second report in relation to the plumbing work and the so we can go to it actually. It's at 689, just so that we're all there. So page 689, page 3 point, paragraph 3 point, sorry, 690, apologies, 690, 3.3.35. And I think the point is being made here that actually plumbing work was 93% with 7% remaining, and based on 294 days, there's 20.6 days remaining, which is more than the aluminium works, correct?
yes.
So in relation to this, sorry, apologies, 1 second. Okay, can we go to paragraph 6.1.8 of your first report? So I'll get to that. Okay, so actually it's the exhibit that I need. So it's exhibit BAQ6. So let me try and find where that is. Sorry, this came through relatively recently. So it's document 3735. And then it's the Excel, so you're going to need to press on it. Have you got that open?
Sorry, I'm behind you. What page did you say?
Apologies, it's page 3735.
Yes, I'm there.
And then it's.
And there's an I see. There's a hyperlink, and you want
Yes,
to
there's a hyperlink.
Yes, I
Yes,
see.
yeah.
Yes, I see.
Sorry, to clarify, so this document is a dashboard from the 28th of October 2019. And the reason why I'm referring to this is to clarify the actual accurate percentage of the plumbing works. And you can see here in item 4 in that table on project status, so it's been revised to 99%, and that's why it's 6% as opposed to 7% as within your as you'd previously referred within your second report.
Well, wait a minute. Wait a minute.
Sorry, Your Honour.
I'm going to need a little help in finding that.
Do you have the PDF open, Your Honour?
I have.
Okay, so if you see under project status in the middle of the PDF, sort of directly in the middle of the PDF, on the original tab.
On the original tab. Well, wait a minute. Something's gone now.
So if you see, it's on the tab that says dashboard, which is the one that opens when you open up the document.
It says dashboard, cash flow, progress curve.
It's the one on the far left.
I see. On the far dashboard.
Yes.
Yes.
And then in the middle of that document, the very middle, it says project status.
I'm terribly sorry.
No trouble at all.
I tell you what I've got. At the top left, there's progress curve, cost based, and then to the right, there's cash flow.
Okay.
If you it's page 1.
If you look underneath progress curve, there's a bar that has there's a blue bar that has project status.
Got it. So I click on that.
I don't think you need to click on it. You can just scroll down over it.
Yeah.
And then you can see underneath project status, there's various different items. Can you see those?
Yes, I see.
So I'm looking at item 4, plumbing work.
Yes, I'm there. Yes.
Thank you. So it says here, revised 99%, actual 93, and so 3%. Sorry. So 6% is in fact the correct figure as opposed to 7%. That's the point that I'm putting to Mr. Allen. So within Mr. Allen's second report, it says 7% remaining, which is why the remaining amount was allegedly a longer period of time than the aluminium works. The point that I'm putting is it's actually only 6%, not 7%. Do you have any comment on that, Mr. Allen?
Yeah, I think the bigger thing to look at is the nature of the work that was being undertaken. You know, as I mentioned, there was extensive MEP work still going on, and indeed post-termination there was MEP works going on. So I don't find it convincing that the critical path is going through the balustrades at all. Okay,
well, what wasn't quite the question. The question was, do you accept that it's 6%, not 7%?
I'd need to revisit the basis for our 7%, but again, you know, this is a report. Whether it's 6% or 7%, it's a rather small difference, obviously. So I need to look into the details, but I accept that this document shows 6%.
Okay, thank you. If we go to back to your report, page 689. And I'm looking at 3.3.3. sorry, 690, 3.3.37. I apologize, so it's the next two paragraphs, but I think it's a related point. So the point being made here is at 3.3.38, the ground floor at the basis of Mr. Singh's aluminium calculation. So the ground floor is the basis of Mr. Singh's aluminium calculation, and then paragraph 3.3.40. Sorry, 42. So it's on the next page. So page 691, 3.3.42. And the point being made here is that I think it's the second half of that paragraph, the aluminium works on the ground floor are actually complete on the 19th of September, not the 6th, and the ground floor did not require any balustrade. So I think a combination of those and 3.3.41, there's no activity to install them on the ground level. So I think the point being made by Mr. Clark and yourself is that Mr. Singh's carried out his analysis in relation to the ground floor, but actually the ground floor did not contain any aluminium balustrade. Is that correct?
Yes, it would appear so, yes.
Now, if we just go to, one second. If we go to page 591. So this is the table that that Mr. Singh has produced here in relation to the balustrade, or the aluminium works even. And again, Mr. Singh can be cross-examined on this point at the appropriate juncture. But I think Mr. Singh has not been pushing his critical delay path through just the ground floor. You can see that the 6th of November is the same for all of the floors. Not just the ground floor. I think there might be an error in relation to the ground floor. And the reason why the ground floor date has been taken is because you can see in relation to the planned completion, the ground floor was originally planned to be the last item completed. So what Mr. Singhal is doing is calculating a subtotal, so the maximum planned to maximum total, as opposed to linking it through the ground floor. Does that make sense to you, Mr. Allen?
Yes, I can see the table. I'm not sure of the source of the data, but another relevant issue is the reasons for why the balustrade work was where it is. And one of those reasons was problems with MESC's subcontractor non-payment problems. And another was the delays in developing the live and the wind load issues. So those are predecessor activities.
Okay, so, we'll come on to those, Mr. Allen. You'll have an opportunity to give your evidence on that in a moment. Just briefly before I do that, there's just one or two more. So I think one more question on something similarly related but slightly different, and then we'll be able to explore that issue. So again, we'll go to page 690. So the reason why I'm doing this is because there's a variety of different comments made by yourself and Mr. Clark in relation to this activity, and I need to go through them. So I'm looking at paragraphs 3.3.40 at the bottom there. Apologies, siren. And it says, so the point being made here is that there were other metalworks still not completed. So the only metalworks not completed prior to the 6th of November 19, and this is in relation to the ground floor, as I understand it, so the handrails, bicycle rack, etc. But it's right that these are all pretty minor items, aren't they?
Yes.
And so they wouldn't be on the critical path.
Yes, well, those were the only outstanding works. Everything else was finished.
Yeah, the ground floor. Yeah. Okay. All right. Now I think we'll finish off with the reasoning for the aluminium balustrade. So whilst I'm on this issue, I'll go into one other point on it. 1 second. So 3.3.49, and this is on page 692. So 3.3.48 and 49. So these two paragraphs here, and I think the point being made by yourself, Mr. Clark, is that there are all activities. So there's a reference to these glass partitions and installation of shower partitions, and in 3.3.49 it says that these all remained uncompleted. So the shower partitions were still uncompleted. And so the balustrade works were not the only aluminium activity which was not completed at the termination date. Correct? So the point being made is possibly this was concurrent delay at the time. Is that right?
Yes, that's right. There were other activities existing at the same time which had fallen under the same aluminium works heading.
Okay, and I know that I've asked this question of you a number of times, Mr. Allen, but it is relevant to our case on this, so I'm going to put it again. Neither yourself nor Mr. Clark have conducted a analysis to establish a linear critical path for the project, so you're unable to confirm authoritatively whether there is any concurrent delay here or not. Do you agree with that?
No, I wouldn't agree with that. We have considered the critical path in each month and at the time of the notified events. So that's the basis of our analysis. To the best of the data that's available within the monthly updates, we've considered concurrent delays, but those programs are not, let's say, they haven't been prepared, to the way you might have hoped. So there are some errors in those programs. Some of the concurrent activities are not visible, but I think that we have relied on the best evidence and we have conducted a critical path analysis.
In relation to this then, so, and as you say, on your own analysis, you've been relying upon these updated programs. If you just go up to paragraph 3.3.43. So here, even in your own analysis or the evidence that you rely upon in relation to these programs, they still show that the balcony railing and balustrade was on the critical path from April until October. Is that right? Or in relation to some of the updates, sorry.
Yes, some of the updates appeared to show that, but that was been driven by predecessor delays. Okay.
Well, finally, we'll come to the point that you were mentioning earlier, which is apologies. Sorry, before I move on, whilst we're on it, just in relation to the partitions that we discussed earlier that were still ongoing at the time of termination, as well as the balustrade. Wouldn't you agree that the balustrade is a much more significant amount of work than shower partitions?
Well, it probably is. Of course, it's a safety critical thing as well, but it's still a relatively insignificant part of the overall project, which at the time was in reality being driven substantially by MEP work.
But you say it's been driven by MEP work, but you've just conceded that in relation to the updated programs, they still showed that the partitions were on the critical path, didn't they? So even on your own analysis, or the evidence that you've used for your own analysis, the balustrade's still on the critical path, isn't it?
Well, some of the updates showed that rightly or wrongly, and the reason that if that was the correct analysis, the reason that they showed that was because of MESC predecessor delays. But I think when we consider the volume of work that was remaining at termination, you can see quite clearly, in my opinion, that the critical path to completion could not simply be through relatively incidental balustrades.
Just in relation to these balustrades versus partitions point, I think, as you said and you accepted, the balustrade is a more significant activity, and there is also a safety critical thing. So would you accept then that it's very likely that the balustrade is more critical than the shower partitions?
Well, it depends what you're measuring that criticality against. Yeah, I mean, both are needed for completion of the project. So I don't see, you would necessarily need to differentiate between them. They both have to be completed.
I've finally just got 2 or 3 questions in relation to the reasoning for the delayed balustrade design, as we briefly discussed. Could I just take it to page 6113? And what I'm looking at here is, so this is a letter from MESC to NAGA on the 30th of January. So relatively early on in relation to this, well, I say early on, start of 2019. And you can see here within this, and I want to look at in particular paragraphs.
Can I just note that letter's dated 2020.
2020, apologies, not 2019. I do apologise. No, you're quite correct. So it says here, though, paragraph 5 and 6. So it says here, the attached qualifications in the above letter, so it references a letter in July 2018, highlight that there are these, the issue was in confirming what glass balustrade design was to be confirmed. Is that correct?
Well, I don't know, it's not my letter, but I think this is the so-called EOT4 submission that came post-termination.
Well, if we go down a little bit, and we can see some of the comments here. So paragraph 7 on page 16114. And it says here, the engineer was indecisive on the balcony balustrade design, whereas requested further options such as mock-ups with concrete stand, without concrete stand. So the engineer and Panther were requesting different options in relation to the balustrade. Is that right?
Well, my understanding is that NAGA was continually not satisfied with the submissions that were being made on the balustrades, and there was a number of letters where NAGA had written to MESC setting out their complaints about why the specification requirements weren't being made. So I think that's one of the issues, and there was problems with the wind loads hadn't been demonstrated, etc. So
if you have a number of different options though, with varying thickness and one with concrete, one without concrete, this isn't a question of just specifications. It's a question of design, isn't it?
Well, I need to look at the underlying. I mean, this is just a statement in a letter. We need to look at the underlying evidence, but that was my understanding as I explained it. Okay.
Well, let's not look at the letter. If the engineer or Panther, either or of them, had requested for provisions of different designs and hadn't actually finalised the design, would you agree that that is a question of design as opposed to a question of the calculations not being correct?
Yes, of course. If the engineer or employer asks for changes to the prescribed specification, or let's say shop drawings were already approved and the engineer wants a change to those shop drawings, I mean, that would be a employer-engineer liability issue, but I can't say if that existed in this case. From what I've seen, it doesn't. But
okay. Finally, in relation to this, just on, if you go to page 5220. And this is, again, it's Annexure 4, which has been prepared by Massin in relation to this specific event. And I think what has previously been discussed, and it was set out within the contemporaneous programs as well, As I understand it, these activities weren't critical until about April 2019. Now, from April 2019, we can see what's happened here. 21st of April, they've attached a letter with the revised calculation, so increasing dead load and wind load. But we can see that what I've been discussing earlier, that on the 13th of June 2019, there were still these mock-ups being prepared. And so it's still clear that even by June 2019, the claimant hadn't confirmed what type of design was wanted for these balustrades. Is that correct?
I don't think that's correct from my understanding. It was more of a case, as I understood, that MESC were trying to demonstrate that what they were providing was fit for purpose. So hence the engineer had gone back to them with concerns about the dead load, wind load criteria, etc. So from my understanding, it was more a case of, is the product fit for purpose? Are the mock-ups acceptable?
Okay. Thank you very much, Mr. Allen. Your Honour, I don't know if this is an appropriate point for a break. I've finished my cross-examination on delay now.
Yes.
So the rest of my cross-examination from Mr. Allen will concern quantum.
Yes. Can you give me a rough idea of how long you think you'll be on quantum?
A shorter period of time than the delay. I'm just trying to think how much shorter. It'll certainly be done today, and I'm hoping we can get on to Mr. Feedhouse as well. Not Mr. Feedhouse, sorry, Mr. Paul. I'm just trying to think how long. How long was my cross-examination just then?
Well, did you start at 11 o'clock? I've forgotten.
I think it was, just about 11 o'clock, wasn't it?
So, that's 1 hour, 50 minutes.
Yes, so I'd hope it wouldn't be over. I'd hope it wouldn't be over an hour and a half.
Yes. Might I just intervene to say, Mr. Paul is here now, and it's 3:52, so it's coming up to 4 o'clock. If that is the case, I think perhaps we should release Mr. Paul for the afternoon.
Yes.
Because it would be 5:30 before.
Yes.
And then
yes,
Mr. Paul could come back tomorrow morning.
Now, can you remind me, are there some witnesses that can only be heard at some particular times, giving rise to the possibility of interventions?
Yes, there's one witness, which is Mr. Burrell's witness, Mr. Singhal, and he's available all day tomorrow. I would be keen for Mr. Paul to finish, and I think then we would still have plenty of time. I can signal, I think, and I know my predictions on time have been not great so far, but I can signal that I will not be cross-examining at this level of detail in relation to delay with Mr. Singhal or
yes.
anticipate on quantum.
Yes.
I would anticipate, if we finished with Mr. Allen today, that with a good wind, depending on how long Mr. Burrell will be with Mr. Paul, that we can finish all three tomorrow. And that's genuinely my estimation.
All right. Well, now, do we have, I think a break is appropriate. The question is how long. So how long a break can we have whilst being reasonably sure that we can conclude Mr. Allen today?
I'm fairly certain we can conclude Mr. Allen today, Your Honour. I won't be as long in quantum as I was in delay, certain.
But
likewise,
how long a break can we have at the same time as you being able to conclude Mr. Allen before, let's say, well, around 5 o'clock, 5:30 Dubai time, which would be
an hour and a half from now, yeah.
I think I'll be about an hour and a half, hopefully less. But I've gotten into trouble before with giving shorter estimates, so I'll try not to do that. But I think I can be done in less than half an hour. But I'd say half an hour is probably the longest it's going to be.
Very good. And for my part, I only have a very small, less than a handful Yes.
Well, 25 minutes, I think, we break now, which will mean that we resume at 20 past the hour.
Thank you very much. Thank you.
Mr. Allen, you'll know the rules. You mustn't talk about the case at all until your evidence is complete.
Yes.
Everybody. Good. Right. Adjourned until 25 past the hour.
Thank you.
Thank you. Thank you.
Thank you.
Are you ready to proceed?
I am, yes.
Go ahead.
Thank you. Okay, thank you, Mr. Allen. We're moving on to the quantum element of your evidence now. The first one I wanted to just go through, if you just go to page, or first item I wanted to address, if you just go to page 700. So this concerns materials left on site. One of MESC's claims. And what I wanted to just do is I just wanted to look at your approach in relation to this. And in particular, so paragraph 4.4.7, you say Mr. Single has assessed this claim at 247 based on the documents available to him. And you say, whilst I agree that Mr. Single that the invoices and other documents support the amount of the assessment, in my view, there's no evidence of the existence of corresponding plant and materials on site at termination. So the reason why you don't agree with this valuation for materials left on site is because you haven't seen evidence of those materials. Is that correct?
Yes, in essence, yes.
So it's right that when you conduct your quantum examinations, you would want to see evidence to support the figures that are being claimed. Is that correct?
Well, in this case, we're talking about physical evidence, the existence of the plant and materials. So, as I say, I'm happy that the calculations seem to support those numbers, but I know that the physical existence of the items on site is denied by Panther, and I've not seen anything to say that the items were on the site.
Sorry, apologies. But the point I'm trying to make is that before you can assign a valuation to a figure, so before you can confirm a figure, you want to see some sort of evidence which can confirm or validate that figure. Would you agree? Yes,
of course. Either that would be through a partial or a full audit of the underlying cost records.
Okay. Just so that I don't have to come back to this point, I'm going to move on to another point in a minute, but just so I'd have to come back to this point, as I understand it, the valuation that you gave in relation to this is the assessment of 80,000 dirhams because of what was stated within Panther's witness statement, but you've not seen any documentary evidence confirming that figure. It entirely relies on that witness evidence, doesn't it?
Well, that came up further to my investigations, and in truth, that's something of a concession, if you like, from Panther. So because they were willing to, if you like, offer that figure, I've recorded it in my report.
Okay, but it's right that there isn't any documentary evidence confirming that figure.
No, I mean, in a sense, it's an ex gratia item, but I'm just in a way, I'm just communicating the position that they're conceding that 80,000.
Okay. No, I know. I understand the point you're making. So the next item I want to address is work done. Now, your assessment in this comes in your first report, and in your second report, you simply say that Mr. Single must have not reviewed the documentation that you had reviewed. In particular, I think it's this 8th of December valuation. But let's just go to page 502. And in particular, So here you can see paragraph 6.1.2, you say, Panther rely upon the engineer's valuation at termination. And then if you just scroll down, sorry, just quickly, in relation to this point, when you say the valuation at termination, do you mean the valuation that was carried out on the 4th of November?
Yes, this is alluding to the 4th of November one, yes.
Okay. Now, we discussed this with Mr. Reswick yesterday, but to clarify, this is a valuation carried out before the termination notice, which was issued on the 6th of November. That's correct, isn't it?
Yes, when I looked into the details, I noticed there had hardly been any movement since the previous valuation. So it seemed to me that it couldn't have been, or it appeared it may not have been properly updated. So that's when I investigated the matter with Panther, and they were able to provide me with the 8th of December valuation, which the engineer had carried out, which did seem to, at least to my eyes, properly take into account the circumstances at termination.
So you say that it's your view that the valuation that was carried out on the 4th of November did not appear to be reliable because it wasn't adequately updated.
Yes, it appeared it hadn't been updated. I was aware at least there'd been some site, it looked like there'd been site activities in September and at least in early October, and that the cutoff for the previous valuation was end of August. So when I looked at the actual quantities within the two valuations, very little had changed. So that's when I was concerned that possibly it hadn't been updated to reflect the termination status.
Okay, so as you say, it's your view that the 4th of November valuation did not appear to have been adequately updated by the time that it was issued, as compared with the August valuation or the August certificate. Is that right?
Yes, it would appear so, and the 8th of December valuation did update certain progress, but it also made certain corrections to the previous valuation, which in some respects was actually slightly overstated. So therefore the overall value between the two valuations didn't actually move much.
Okay, well, you've rather preempted my next question there, Mr. Allen, which is that the 8th of December valuation is 85.15, so it's only 0.5% of additional progress. But I know your answer in relation to that.
I can just explain there was two particular items there, why that had arisen. One was in relation to the variations, which in the 4th of November valuation, the engineer had allowed full value at 1.668 million, when in fact they hadn't taken into account that not full progress on the value had been made. So in the December valuation, they adjusted that to reflect only progress on the variations, which reduced it down to about 1 million. The other issue was the omitted kitchen units. That there was a double deduction in error in the 4th of November valuation, which was subsequently corrected in the December valuation. So between those two items, there was a downward adjustment of something like 1.4 million, which tended to offset the increase in progress in the valuation.
Okay, so in the December one, and so in the November one, they doubly deducted the kitchen units, which was omitted, but it should have only been omitted once in relation to the variations or wherever it's done.
Yes, the item had been omitted from the bill of quantities valuation and within the variations, but the error was corrected in the December valuation.
In relation to this 8th of December valuation, now, you were initially not provided this, were you? You had to request for this document to be provided after you'd initially reviewed the 4th of November one. Is that right?
That's correct.
And we'll come to it in a moment, but it's right that this is only in an Excel format as far as we are aware.
Yeah, sorry, just to go back to the first question. I mean, I wasn't aware of the existence of it. I just raised the question in my inquiries to Panther. Is the valuation doesn't seem to be up to date? Is there any better valuation or other evidence I can look at? And then Panther were able to provide that to me. But yes, it is only in an Excel format. So I'm assuming that it was never formally communicated, at least to MESC.
Okay, yes. Well, in relation to that point, in your experience as a quantum expert who has reviewed these types of matters and been involved with sites yourself, would you agree that the vast majority of the time, if you were to formally communicate a valuation, it would not be in Excel format?
Yes, I would say so. Of course, I assume that the reason that wasn't communicated was because it was a post-termination document. So I suppose there wouldn't have been any communication from Panther and the engineer to MESC at that point.
Well, I'm not going to take you to the contractual terms on this. We went through them yesterday with Mr. Rezic, but you can take my word for it that it's an obligation of NAGA to conduct a valuation after termination and to provide that to the parties. Whether that was done or not, we'll deal with in closing submissions. Okay, well let's get to this document itself, which is I think it's at K81. So let me try and get the right page reference. So it's at page 3736. Apologies if I think this is the correct one. Yes, I think it is. So it's one of those Excel files that you'll have to open up. Do we all have that?
Yeah.
Do you have that, Mr. Allen?
It's just opening now.
Okay. Sorry. Okay. So before I address a question in relation to this evaluation, have you been provided with any contemporaneous evidence which would support the figures within this? So any IRs or other contemporaneous evidence which would support the figures of this document?
Well, I mean, the valuation for the whole of the works is quite a large and complicated issue. So it wasn't feasible or possible for Mr. Singhal or I to go back to absolute basics and do a full valuation. So, I mean, what I've done is, if you like, relied on what appears to me to be the better evidence. There are a number of consistencies in the latest MESC valuation. And as I say, I did query the inconsistencies in the 4th of November engineer valuation, which led to the production of the December valuation, which did seem to address some of my concerns about errors and possible missing progress. So that's why I've adopted that valuation.
One of the items in relation to this is materials left on site. And I think if you go into Appendix A, we can see materials left on site. And it says 202,000. Sorry, materials supplied by the client. Sorry, not left on site. Apologies. So materials supplied by the client. So that's in row 41. And column K is the number that I'm interested in. Can you see there that it says minus 978,000?
Sorry, this is tab. Which tab is it again? Sorry.
So tab Appendix A.
Appendix A, yes.
Tab Appendix A, and I'm looking at column K,
Yes.
line 41. And so you can see there it says a negative of 978,000.
Yes.
And in particular, you can see this month. So this is the change between the previous and this month of minus 568,000.
Yes.
Would you agree that's quite a substantial increase in the material supplied by the client between the previous assessment and this assessment?
I think, in fact, it's a reduction versus the previous month.
Well, it
initially was 1577.
Mine.
Sorry, excuse me. I think I'm looking at the
variation.
The variation. Sorry, the row again, please.
Sorry, it's row 41. Material supplied by the client.
41. Yes, I have it now. Yes, 978.
Yes, and so you can see in previous it's minus 410,000 or thereabouts, and then minus 568. So would you agree that it's a very significant increase in relation to these purported materials?
Yes, it does go up somewhat. I think that, well, it seems to me, reading between the lines, that the engineer has gone back and revisited, substantially the valuation. So as I say, they've corrected some oversights where they'd effectively undervalued, and I assume that they again have picked up or updated this material section in a similar fashion.
Have you seen any documentary evidence supporting this materials figure?
Nothing other than the valuation. If you click on the figure, you'll see the breakdown, the engineer's breakdown.
Do you have to enable editing to get that? Or no, I think what you mean. Do you mean the calculation in the equals in the formula bar? Or
yeah, sorry, one moment. Sorry, my page is refreshing now.
Well, I clicked on the figure, and that has produced Appendix E, setting out in tabular form Appendix E is headed Materials Supplied by Client Deduction plus PC Rate Adjustments for the materials supplied by contractor. Am I looking at the right thing?
My Appendix E says contra charges, employer claim, delay damages.
Well, this is what came up when I clicked on the figure, the minus figure, the 947, whatever it was, in line 41.
If you double click on it, you mean? Yes.
Yeah.
Yeah, I can see that. Yeah, no, I'm on the same page as you. Okay, so there's a calculation there which comes to the 978 figure.
Yes.
I suppose the question is, you've not seen any documentary evidence outside of this Excel table figure, is that right?
No, I mean, I can't definitively confirm that figure. I mean, what I've done for the valuation, if you like, is not being able to, having the time or the data to do a first principles valuation for the whole project. I've done more of a due diligence audit, which was how my concerns come up. But no, I can't say I've seen other underlying instructions or documents relating to that figure.
Okay. No, I think I understand. I understand the nature of the assessment. So you've reviewed the figures within this document, and you've calculated whether they appear to be right, having regard to what the actual claim percentage of completion is, what the claimed or apparent cost of completion is, and that's the way that you've sort of verified this figure. Is that right?
Yes, substantially. As I say, I had a concern that the 4th of November valuation wasn't up to date, and I think that concern proved to be correct. But I was fairly satisfied when I reviewed the December valuation that the engineer, he'd addressed particular items, and he seemed to generally have revisited the valuation and updated it.
Okay, well, we're on this point, so we'll come to it now. If you could just go to tab 01. And then if I could get you to, if you're not already there, could I get you to scroll down to items, so that you have items 74 at the top. So line item 74 at the top. Or near the top.
Yes.
So we can see here, and this is a point that's made by Mr. Singhal in his report, or an observation that's made. We can see here in column G, there's it says 10% and 69%, and then at the bottom 88%. And then in current, there's 3 zeros, but it says -9%. And then in the I column, it says 79%.
Yes.
Something's gone on here, but it's reduced 88 down to 79. Is that right?
I couldn't confirm that the 88 was in the previous valuation or not. I think there's just an error in cell G106, because if you click on that cell, you'll see that there's no formula. So I think the formula should have captured the 10% and the 69% above, which would give you 79%. But if you look at the actual calculation of the gross 395 figure, there's no error there, and it does rely on the 79%.
Okay. I think we went through this yesterday, and I'm not going to propose going back to it, but we went to the payment certificate yesterday, which showed that the 88% figure is correct. That was in the previous figure. So has this been manually rounded down? Is that the effect of it?
I don't think it's been rounded down. I mean, if you look at row 75, 76, the engineer's opinion seems to be a 10%, 69% recovery against the lump sum. So, and in column G, that they seem to have, well, apparently they had the same opinion the previous month. So I think it may be that the 88% in the previous month was simply an error, because the formula is not in that cell. So he possibly hadn't noticed that the formula hadn't captured the 79%.
Again, well, we can go to this if necessary, but you can take my word on it for now. And so if you take my word on it, in this column G, in the previous payment certificate, the figures in G 75 and 76 both added up to 88%. And
Okay.
so that was the correct figure within this column. But then it's been rounded down for this valuation manually. Is that right? If you assume what I say is correct.
Yeah, I mean, the whole valuation is manual. It relies on the input into the cells. So yeah, if what you're saying is correct, the engineer has revised his opinion on the progress downwards from 88 to 79.
Would you agree that that would be unusual in relation to this specific item? If it's already been previously certified, it's not clear why that would be rounded down.
No, it's not unusual. I mean, all the valuations are interim until it becomes final. So as I mentioned, he's corrected some other errors, a number of them in favour of MESC. So I think it's just indicative again of the engineer appears to have, on the face of it at least, been quite diligent with the December valuation and has corrected errors and perhaps revisited all parts of the valuation. But it's not unusual for a valuation even to go down in an interim valuation to go down, or parts of it, in a subsequent month.
A final question, and specifically on this point. And I know your presentation deals with this point to some extent. So I think we know what your evidence is likely to be on this, but we'll just address it briefly. go to L14, so that's page 4363. Over here on 4363.
Yeah, just give me a moment. I'm trying to get shot of what's on the screen at the moment. Sorry to hold you up.
No trouble at all.
At the moment, I'm looking at what we were looking at just a moment ago, and I've got to clear that off in order to get back into the e-bundle.
Okay.
And how do I do that? How do I get
Essentially, press escape,
escape?
and then that might take you out of the Excel.
Are you able to close that Excel, Your Honour?
Well, if I tap on the let's see if I can do that. I must be able to close it, mustn't I? Oh, that's better. Wait a sec. Yes. Thank you very much. I found the little cross to click on. So where are we going now? What page was it?
It was page 4363, Your Honour.
436. Thank you.
No, 4363.
4363. Yes. Minutes of the meeting. Yep.
So now I note your presentation in relation to this, which is that in essence these are not necessarily reliable percentages, because they're not, or the percentages can change once a formal valuation is done. But if you see item 2.2a, in these agreed minutes, it does say that as per the proposed programme, the actual completion percentage for this week was 63.2%. So would you agree this is evidence that the percentage as of the 23rd of October was 63.2?
Sorry, 93.2.
So 93.2. Oh, sorry, not 63.2. 93.2. Apologies.
Yeah, I had thought that was the intention, but now when I reread that, I'm wondering if that's the progress versus planned for the week.
Okay, well, we can go. Just wait 1 second. There's a slightly different contemporaneous document that we can go in relation to this. It's from September. If we go to 4354. So this is dated the 10th of September, and it's the manuscript here. And you can see here, and it says, looking at the second paragraph, as per the programme, the completion for works have to be within this September 2019, some small amount of works up to mid-October. That means if we consider that 87% is the completed percentage up to date. So that means a percentage up to date, so of the completion of the works, right?
Yeah, sorry, I'm just not seeing the 87%. Where is that?
Apologies, it's 4 lines down from the second paragraph in red. I'll give you a chance to read that.
It's at the beginning of the line, four lines down.
Yes.
In the second manuscript paragraph.
Oh, yes.
So my understanding is what that's reading there, and similarly in the document that we just reviewed is that this is evidence suggesting that this was the percentage of completion up to date rather than a weekly percentage.
Yes, see that seems to be the engineer's comment, and they're indicating that mid-October, by whatever measurement metric they're applying, we consider that 87% is the completed progress. I guess they've done that with reference to, I mean, whether it's just a impression or if they've done it with relevant to program activities, I'm not sure, but yes, I see the figure.
Okay. Well, the only reason I went to that figure is to demonstrate that I think if we go back to 4363, the document that we were on earlier, and 2.2a, so obviously this is in 23rd of October, sometime after, but the figure there is 93.3. So the point I'm suggesting is that this is a figure for actual completion rather than just the completion for that week.
Right. Okay.
Okay. Well, let's assume that that's the case just for now, that's what this figure is supposed to represent. Would you agree that 93.2 is quite a significant disparity to what NAGA ultimately concluded, which was 85%?
Well, I mean, I don't know where, how the 93 was calculated, but it appears to be, I mean, if the 87% has somehow been calculated with reference to the programs, maybe it's the number of activities complete, for example. When they look at the P6 programs, they can see the number of activities that are in front of or behind the data date. So that might be one way how they derive the program percentage. But I think that's not necessarily indicative of the value of work. I mean, some activities may have a larger value than others, for example. Well,
we see here in relation to 93.2, sorry, in relation to the 3.5 and then the 1.2 figure, because what they're trying to do is they're trying to calculate how long it's going to be left to complete, correct?
I suppose so, yes. They're discussing the program, yes.
Required weekly percentages. So it suggests that this represents the actual completion as it is at that time. Is that correct?
Well, it's an indicative figure calculated by what means I'm not sure, but yeah, that seems to be the intention. I don't think anything hangs on the figure. I mean, they're not. It doesn't impact on MESC's entitlements one way or another. It's just a discussion for progress purposes.
I understand. Finally, on this topic, yesterday we heard from Mr. Rezic, and I'm not going to go back to the table, but the 85.15 percentage that's within the within that Excel of the 8th of December. Mr. Rezic confirmed that was actual and financial. So the figure for both was combined. So it was actual completion and financial completion. That's what was confirmed yesterday. Does that make sense to you?
Well, I mean, it would be. It depends how you measure actual progress, but because the valuation is quite a detailed document. I mean, it's quite logical to measure progress against value, but I don't think there's two different calculations that coincidentally come to the same figure. I think that's the amount that comes out of the valuation.
Okay. All right. Well, I'm going to move on to a slightly separate topic now. Firstly, so if we could just take it to page 845. So this is Mr. Singh's second report. And in particular, I just want to look at the table that Mr. Singhal has created under paragraph 75. And in essence, what Mr. Singhal has done here is he's just referenced that within the value that you've used for computing, I think it's in relation to liquidated damages, the figure that you've used is 41811,532, whereas the figure for using the computing valuation of the project is 41878,294. Have you had an opportunity to review this within Mr. Singhal's second report?
Yes, I've seen this before. I mean, there's a very small margin between them. I guess I was being slightly conservative, and I realised there would be a concern that the December valuation hasn't been formally issued. So, as I say, being conservative, I just adopted the valuation that had been disclosed between the parties. But the difference in the numbers is rather negligible.
I agree. It's a minor difference, but there's a contradiction between the sources of your data. Is that correct?
No, I don't think there's a contradiction. I mean, you see in my report, I've referred extensively to both of those valuations in their relevant context. So for the purpose of this delay penalty calculation, I used the formally disclosed document. I thought that might be more appropriate.
Okay, I'm gonna move on now to the cost of completion. So now I know you deal with some of these items within your presentation. In relation to the cost of completion, one of the main criticisms that Mr. Singhal raises is that in 8 out of the 38 instances, the PO or the subcontract was issued to the subcontractor prior to the date of termination. Do you agree with that statement?
Yeah, that was the case in some instances, but the work in question, which is the subject of the invoices, was carried out post termination.
If I could just take you to K3, so that's page 2384. Sorry, it's another one of those Excel files.
Can you give me the page again?
Sorry, it's 2384.
Thank you.
And then I'm looking at item 20.
Yeah.
So do you have that, Mr. Allen?
Not quite, if you just give me a moment.
Of course.
Yes, I have it now.
So you can see in item 20, this is for in-step trading. And we can see here that the invoice is dated the 18th or 19th of June 2019. So why would an invoice be issued for work done before termination? Sorry, I'll rephrase that. If the invoice was issued on the 19th of June 2019, would you agree that that appears to be for work done before termination?
Yeah, I think I'd mentioned this on my slide 25. The agreement to this was apparently originally MESC's scope of work, but there seems to have been a pre-termination agreement that Panther would take it over. So as I understand it, the payment pre-termination was an advance payment but the actual works were carried out post-termination.
If, and now I know I'm not. This is more of an entitlement point. So and I appreciate that you're giving your evidence as a quantum expert here. But if as I see it, if there was an agreement before termination for these works to be de-scoped, surely these aren't a cost of termination. Wouldn't you agree with that?
Well, that would be logical, but assuming that the scope has been removed from the valuation. Now, in some cases that was the case, and I've noticed that, so I've made sure that those costs are not double counted for here. But if the scope remains within the valuation, then I think it's appropriate that it's included in these costs.
Well, I think that's an area where we disagree, Mr. Allen. As I see it, if Panther has engaged contractors before termination, then the work that they're undertaking must necessarily not be a cost of termination. Is that not correct?
But if the valuation of those works, the scope of those works is credited to MESC, then it remains appropriate that it has to be accounted for post termination.
Wouldn't that be part of the valuation exercise that was done by NAGA? So shouldn't that have been taken into account by NAGA in their valuation?
It should have been, but there are a few instances like this one where that hasn't happened. But as I say, there are other cases where the original breakdown that I received from Panther did include costs which had already been accounted for in the valuation. So I removed those costs.
Okay, but in relation to this item, are you suggesting that actually MESC were paid for this item, or sorry, this item featured within the valuation?
Or at least it's within the credit, which is the 8th of December valuation.
Okay. Are you aware of any valuation conducted by NAGA in relation to the cost of completion?
They certified the major works packages, but not the more incidental works.
Sorry, let me rephrase it. Are you aware of any exercise that NAGA did in terms of valuing the remaining works that there were to be done? The entire cost of completion, as opposed to certifying individual items of work?
There was, I recall, I'm just trying to remember when the letter fell, but I know I may be confusing. I know that NAGA did carry out an assessment of the claims submitted, but I don't recall that they considered in particular completion costs.
Okay. It's in relation to this cost of completion. It's right that there's also a rolled up cost of remedying defective works. Is that right?
Yes, some element of the costs will include defective works. Yes.
But we don't have any documentation which distinguishes the exact cost of remedying these defective works as opposed to merely completing, do we?
No, the orders that were placed with the suppliers, the subcontractors, don't differentiate.
Are you aware that, well, this is a legal point, so I'll leave that for submission in relation to the defect. Okay, so whilst we're still on this, it's right that Panther would not be entitled to claim any sums for works which were outside MESC's scope, wouldn't they? So they wouldn't be entitled to that. Is that right?
That's correct, yeah. And I've tried diligently to make. I mean, the actual the value that Panther had originally produced of their cost to completion. I mean, it was their cost to completion, but it also included some items, as you're indicating, that weren't MESC scope. So I was carefully went through to try to make sure that I excluded such items.
Okay, so it's your evidence that you've checked the specifications and the details of all of the newly awarded work, compared it with MESC specifications, and excluded items. Is that your evidence?
Yeah, as best as I could on the available evidence, I've excluded any items that do not appear to be MESC scope. And as I indicated in my slides, I do agree with one point that Mr. Singhal raised, and I've omitted, or I'm omitting during this evidence, the amount for the excess platforms figure, and also the MTC landscaping.
So just in relation to that, to the comment that you just made there, so you said that you have conducted this exercise of checking the scope and the old scope as best you could on the available evidence, correct?
Yes.
It's right, however, that in relation to a large amount of the documentation that was submitted, it's not possible to evaluate actually exactly what that scope is. Is that right?
Well, when I went through the exercise with Panther, I asked them if it wasn't obvious to me, I asked them to identify the relevant bill of quantities and etc. where the same scope was described. So I think I put those notes on my appendices. So I was fairly satisfied at the end of the review that the items which remained were part of the MESC scope.
Is it right to say that where the documentary evidence wasn't as full as you would usually want it to be, you would assign that cost, or you would assume that it was in fact within MESC scope as opposed to the other way around? Is that right?
No, I don't think that would be fair. I mean, I put the onus on Panther during my investigations. If I couldn't see that it was obviously in the scope, I put the onus on Panther to explain to me why it was within the scope. So I think I was quite fair to all parties in that respect.
In relation to assessing these items, it's right that you'd usually want to see certain documentation to verify the issues that we've just discussed. So as I see it, there's a couple of points you need to verify. You need to verify whether it's within the same scope, whether it's related to the project at all, and whether it was completed. Those 3 points, is that right?
Yes, that seems reasonable.
And in relation to that, to ascertain those 3 points, wouldn't you usually want to be able to see the PO or the subcontract, a bill reference, and engineer certification? Wouldn't you usually expect to see those 3 things?
Well, those are 3 things that you might have, but not, in some instances there may not be a purchase order, or there may not be an engineer's certification. So you just go with the best evidence that's available.
Well, I think you've seen Mr. Singhal's report in relation to this. He says that in 25 out of the 30 invoices, 25 out of the 30 items for which the PO or subcontract was after termination, there was no engineer certificate. In 10 out of 30, there was no subcontract or PO. I think 2 of those, there was only a partial. And in 12 out of 30, there was no bill reference. And it's because of this document deficiency that he's reduced the entitlement. So I suggest to you that given this lack of documentation, it's impossible to verify the figures which don't have that necessary level of documentation. Do you agree with that?
No, I wouldn't agree with that. No, I'll refer you back to my slides today, 25 and 26. Now, as I mentioned, the engineer was only involved in certifying the larger packages of work. So the smaller packages were left for Panther themselves to manage. In terms of purchase orders, some of the items don't have a purchase order. Now, whether the reason for that, I don't know, but that's the fact. But one thing I was quite impressed with was the ease with which Panther could produce the evidence of the payments. So there was clear evidence of the actual payment, and there was a formal receipt from all of the contractors. So as I said, I've taken into account the range of evidence that was available. Yes, they didn't all have purchase orders. They didn't all have an engineer's certification, but I think on balance, the valuation I reached is reasonable.
And so in relation to that, you say that you've put quite a lot of weight, or sorry, you were very impressed with the ability to produce evidence of payment. But that doesn't go to the other two items that I just discussed, which is whether they were part of the scope and whether they were even related to these works. So there's still recoverability issues on those other two items, isn't there, even with evidence of payment?
Well, as I say, I did go through that exercise with Panther, and if it wasn't obvious to me the scope was original scope, I asked Panther to help me to identify the relevant bill of quantities and or drawings that were applicable. And I think that's recorded in my exhibit.
Okay, well, I think we have your evidence on that. Two more questions on this. In relation to retention, it's right that in most of the occasions you've relied upon the subcontract, not a book of accounts. Is that correct?
Yes, I've relied on the, well, yeah, I think predominantly on the values that were stated in the original purchase orders. So in some of them you can see that the payment that has been made is, say, 5% less than the total purchase order. So it seems fairly clear that's retention.
Finally, on this, if I take you to page 850.
Could give me the page again, please? Sorry.
Sorry, 850.
850. Thank you.
And this is Massin's report, second report. And you can see here, and what I'm looking at is paragraph 89V, so the paragraph V there, and then A and B. And these are just a couple of sample clerical errors that I think have been picked out. Have you had an opportunity to review this paragraph, Mr. Allen?
Yes, I have. I've made certain corrections, at least within the presentation I made today, but yes, of course, it may be there are minor typographical errors within my report.
Okay. Well, yeah, I'm sure we can deal with those at a later point, a later stage. And it might be that you have them in your presentation, but as I say, it's quite a lot of slides that I've not been able to fully go through there. Anyway, we'll move on. So I now want to come to the claim for other loss and damage by Panther. So in relation to this, I think a large amount of it relates to the company overheads. And if you just go to page 408, and you reference here the extended delay period and then the period including the defects notification period, correct?
Sorry, which paragraph are we looking at?
Sorry, paragraph 4.5.4.
Yes, okay.
And then you see it's a period extends to 28.5 months for those claims that include the defect notification period.
Yes.
So in relation to this, and we heard evidence on it earlier, so I think we can go down, if you just scroll down to the table that you have on the next page, page 409. And I'm looking at first at, oh, sorry, 1 second. I'm looking at company overheads, item 2, the company expenses and salaries. Now, this is for the general manager. As I understand it, this is a regular wage of the general manager, Mr. Bagitov, and the manager, Ms. Galina. Is that correct? I think you've got that. You've noted that elsewhere in your reports.
Yes, that's my understanding. Yeah.
Now, I know this is a matter of evidence as opposed to your report, but if these salaries were a regular expense for Panther in any event, for example, during the defect liability period, would you agree that where they were a regular expense, they would not be recoverable?
Well, I think the issue here was that this was the only project which Panther had. So it seems that the company was established for the purpose of this project. So therefore, you might reasonably consider these to be project-related costs. But I agree with the principle that if there's a larger company that has a remote overhead not directly related to multiple individual projects, then there's not necessarily an additional cost. But I think this case can probably be distinguished from that.
Could I intervene at this point?
Yes.
Does it come to this, that if this project had been completed on time, if this being the single project of the company, it's to be inferred that the company would no longer be paying for these individuals who have to be paid for because the project wasn't finished on time and there were things that had to be done in respect of the project beyond what would have to be done post-termination if it had finished on time. Is that the heart of the point? Yeah.
As I understand it, sorry, Your Honour, I'm not sure if that was directed to myself or Mr. Allen. I do understand that certainly to be the case in relation to the delay period, but there's also a period for defect liability, for the defect liability period, which is 12 months. So I think the suggestion is that these managers would still have been employed by Panther over this defect liability period, regardless of the delay. Whilst there might be an extension of the 16 and a half months that they've had to pay for extra for the delay, during the defect liability period, they would have been there in any event.
I see. No, I understand it better now. Yes, I see. So you say if it had finished on time, there still would have been a defects liability task to be performed, which would have been covered, so far as management is concerned, under this overhead.
Correct.
So there's no necessary causal link between that and the breach constituted by the failure to complete on time.
Yes, that's the point, Your Honour.
I think Panther's position, subject to checking, is that those persons were engaged because of the necessity for Panther to take over the management of the project, and they wouldn't necessarily have been required during the DLP had the main contractor still been managing the works. But that's an entitlement issue.
So in other words, if the thing had been finished on time, the can I call it product liability issue would have been handled by the contractor, and that would have been all rolled up into the fixed sum that's payable for the whole job. But because the contractor has been sent on his way and Panther have had to assume a job that would otherwise be done by the contractor.
Yes, that's my understanding of Panther's position.
Well, I see where the lines are drawn. Yes. Sorry to interrupt you, but that has at least cleared one little area in the judicial mind.
Indeed. No, I'm grateful, Your Honour. I'm grateful. In relation to that point, briefly, Mr. Allen, isn't it right that ordinarily MESC would have been paid some sums in relation to the progress of their works over this DLP period as well?
Yes, well, the progress payments have been taken into account in the reconciliation.
Okay. Okay, moving on. In relation to the office rent, so whilst we're just on these items, it's right that there's no PO or additional supporting evidence clarifying this office rent, is there?
No, apparently there's. I did check that recently. There's no separate PO apparently.
Okay. And so we don't know what the actual basis of the renting or the reason for the renting is in the absence of that.
Well, I think we're relying on the description and the invoice and the payment.
Okay. Moving on. Just in relation to security costs, so whilst we're on this table, you can see here in line item 18, which says June 2020. And that's 17,640. But in June, isn't it right that the project was completed on the 1st of May? So why would this security have been, why would this security item be necessary? I guess the point is, isn't this irrecoverable?
I can't comment particularly to that detail. That the quantum is verified, but I understand Panther's position is that they wouldn't have incurred these security costs had MES continued to complete the work. But yes, possible that the reason for that, I don't know if it's dealt with in the witness statements, but the reason for that June invoice may need further consideration.
Okay, thank you. The other, okay, so just the other point in relation to security costs. It's right that, again, there's no subcontracts or POs as far as we're aware in relation to these items. Is that right?
I don't recall offhand if these had POs, but there are certainly invoices and payment receipts.
And the next item I want to discuss briefly is the development management expenses, and these are all for Town X. Now I'm not really clear what these expenses are for. Do you have any? Have you been provided with any documentation with it which illustrates exactly what these expenses are for?
Well, I understand it was a management service. I don't know the relationships directly between the companies, but it was a recurring management service, so practically a time-related cost. So, but what the detail of the service is, I'm not quite sure.
We don't have any PO or any other documentation which provides any detail on what those services are, do we?
I'd need to again go to the appendix just to double check what it says there.
If you need to go somewhere to go to an appendix, please go ahead.
Yeah, let's have a look. In fact, I think it's exhibit Q26,
which is I can get you there. You might get there before me. Q26, 2.6.
Yes.
This is, so that's page 3283.
Well, there's some description in the invoice there, project design, construction and management services. So it seems to be a regular recurring cost.
And all of this occurs after after the project's been completed, doesn't it? Even if the first one's in June 2020, correct?
Sorry, I've lost the summary now. But...
Apologies. Yeah. Okay. Well, if you want, I can probably get you back there. A second. Do you mean the table that we were just on?
Sorry, the table we were just on. Yes.
Yeah. 409.
Okay.
So we can see in the date column, it's June 2020, July 20, August 20, and February 21.
Yes, that's correct. Yeah.
It's quite a substantial claim in the context of these proceedings, isn't it? It's 455,000.
Yes.
But we don't know exactly, other than that brief description in the invoice, what actually this was for.
Not unless it's addressed in the witness statements. I don't recall offhand.
All right. Well, let's move on. I think we've got the evidence on that point. In relation to the audit, briefly, have you seen a copy of the audit?
I have seen the audit. It's a 40 page document, but I don't believe it's been provided as evidence.
No, well, I've not seen it. And have you seen a copy of the PO, for this audit?
Again, I'm not certain offhand if there's a PO. I'd need to go back to the details, but certainly the evidence of the payment is there. And I say I have seen the report, albeit it's not been submitted as evidence.
Okay, all right, we'll move on. I'm conscious of time. So if we go to page 410, so that's just the next page down. Now you state here in relation to additional engineer, sorry, 4.5.7, and so you've brought across here a figure of 952 in relation to engineer's supervision, underneath or within the cost of completion, correct?
Yes, that's correct.
I just want to go to, if we just scroll up to the above page briefly. So if you look at the engineer's supervision, and if you look at line item 56, you can see here that this is for the period of November 18 to November 19. So that the largest invoice, 776, or which you've given a figure of 739,000. Actually, that's for a period before termination, isn't it?
Well, that's for the original period of delay beyond the original completion date. So it's a delay-related claim, not specifically. Well, it's premised on the delay. So which is yeah.
Yeah, no, I know. I understand that. So it's premised on the alleged delay, but that item shouldn't be within the cost of completion, should it? That specific line item.
That's true. It could have better been presented as the addition to the delay penalty figure.
Okay. And finally, just on the engineer's supervision, we have here a number of items considerably after NAGA were involved, from October 20 and January 21 for ProLead and NACI. It seems to me that these are for a period considerably after completion, and so they don't appear to be related to delay or termination to me. Have you seen any evidence linking any of these invoices to termination or delay?
Yes, I did see let me have a check here. I don't have the records to hand, but I think these were one-off services.
Okay.
Hence the small amounts.
Okay. Yeah, I do appreciate that they're minor, so I'm going to move on for that reason. All right. Moving on to the general damages. So I think this is within your first report, but you give an estimation for the other general damages, which were claimed in relation to this. And you discussed that it's because of the potential lack of the benefit of having a 10-year latent defect period or similar. Is that right?
That's correct, yes.
And you've plucked a figure of 2% of the price, but that's just speculative. Is that right?
Yeah, it's not supported with. There's no documentary support. It's just I think I've qualified my opinion, but that's just my perception based on experience over the years as to how a tender may be priced. But and as I say, I think I've sufficiently qualified that. But
yeah, no, I understand that there's qualifications in your report. So I understand that. In relation to this, so and it may be that this is one of the qualifications that you made or will make. Is there any contractual basis for your view that the multiple subcontractors that were engaged to complete the works wouldn't offer the same level of protection as MESC would offer?
Well, if we look at the purchase orders that are there, I don't think any of them talk about 10-year or decennial liability. I mean, I suppose they wouldn't have signed up for it, but MESC did, in view of the larger project.
Okay, I'll just clarify. Well, it can be a matter for legal submissions if there is in fact this signing on for the 10-year period. We'll leave that for another time. Okay.
I think the actual 10-year requirement is dealt with, and it's introduced via the particular conditions.
Okay, but we can come back to that in closings if necessary. Wouldn't it be usual in these works for the subcontractors to give warranties as opposed to the main contractor, or for a lot of the works?
Well, it may be, but I mean, in the main contract, employer main contract situation, that's a matter for the main contractor's procurement. But the actual obligation, as I understand it, arises from the main contract between the employer and the main contractor. But yes, it'd be usual that the main contractor would try to offset their own liability by passing it on to the suppliers, but whether they succeeded in that, I don't know.
And now just a couple of quick questions. I am getting close to completion, unfortunately. So I next wanted to just briefly touch on prolongation costs, and I think that there's a broad degree of agreement in relation to this, save for just a couple of points. So I think let's go to. I think it's in your second report. Sorry. So this is at page 704. And I'm looking at paragraph 4.9.9. And the point that you make here is that you agree generally in relation to most of the items and everything else, but there's 4 items that you don't agree. And these are the ones that you've set out. Now, it's a brief question that I have for you here, but it seems to me that, well, certainly I know that the overheads are a slightly separate item, but the first 3, these all seem to me, as a layperson, to be time related. Scaffolding presumably would be up for longer if there was a delay, and similarly there would be additional bank charges or connection fees if there was a delay. Is that not right?
Well, they might be time related, but when you look at the actual cost profile, especially for the bank charges and the connection fees, it indicates that they're not, because across the whole period there's only 3 entries, over the 30 months or so. So that indicates to me it's not time related. I mean, had there been a charge every single month, I would have said this is time related. But since there's not, I think it's pretty obvious it's not time related. I mean, scaffolding might also be time related. It could be, but on the other hand, scaffolding's often brought in for specific activities. So that's when you would call it a task-related activity. So again, I think that the cost entries were quite sporadic. So I couldn't say that it was a prelim type scaffolding that was there. So that's why I've excluded it. But as you indicated, I think otherwise we're in reasonably close agreement on the prolongation costs.
No, that's helpful. Thank you. In relation to the other two items related to the delay claim, as it were, or delay damages, head office costs and loss of profit. And now I understand the main criticism that you raise is that under SCL guidance, you would need to clarify that there was other profit-making work available for both of these items, and that's not being presented. Is that's the main criticism you have? Is that right? Well,
that's my understanding of the usual, if you like, legal threshold as to entitlement. But of course, that's for others. But I've made the calculations on the figures also. But yeah, that's my understanding, that if and I think you've made the point that the SCL protocol is not a contractual or even legally binding document, which is true, but it's a document which is often relied on as best practice. But I'll leave that threshold issue for the legal debate, but that's my understanding.
I understand. No, thank you, Mr. Allen. I think the other question I had was that to put to you that the evidence that MESC have provided in relation to these costs, or at least as presented by Massin, illustrate that MESC was a profit-making contractor. And I suggest to you that this is sufficient evidence that they would have been able to get other profitable work. Would you agree with that?
Well, I don't think that's the issue, though. The issue is, have they been constrained by the delays on this project? You know, did they need these resources to get that profitable work? So that question is not answered for me. Okay,
and I've only got two more questions. One is in relation to the period following completion. So a large amount of the claims that are made by Panther relates or are time related, and are time related over the period following termination. And you know, obviously the longer that went on for, the longer that they were incurred. Now I know it's not your job to make a finding in relation to how long that period should have taken, but it's right that even if there was still 15% left to complete, it still took a very, very long time, or much longer time than it should have done to be completed. Is that right?
Well, I don't think that was the case. I think I've mentioned that in my presentation at slide 22, because up until the point of termination, it had taken 28 months to achieve 85% of the work progress. So applying that on a straight line basis, it would take another 5 months to complete the remaining 15%. So I think the fact that Panther were able to complete within 6 months shows quite a good level of due diligence in my view.
But it took 28 months with over a year of delay. See, the fault for that is disputed. So if it then took 6 months, it would also be delayed by a similar proportion, wouldn't it?
Well, there were issues that have been carried forward from pre-termination to post-termination, such as problems with subcontractors and defects, etc. So, you know, I'm not surprised that it took a similar length of time. And of course, there's a learning curve for an employer taking over from a main contractor. So I don't think the time, to me, doesn't seem inordinate in any way.
Finally, and I'm hoping this is a relatively uncontentious question. It relates to the alleged claim for loss of opportunity, which is the subject of later evidence and will be admission as well. Now, if the court determines that, for example, a sales scenario is appropriate, so they take the loss of opportunity based upon the difference in purported sales scenarios. As a brief matter of accounting, would you agree that you'd need to then offset all of the profit that Panther have made on the rentals from the 20th of May to date?
I wouldn't actually like to comment on that. I don't think it's within my scope, and it's tending towards a legal issue as well. So if you don't mind, I'll decline to opine on that.
That's fine. I thought it was just a simple accounting point, but I know your point on there, and I won't push you on it. So we can deal with it elsewhere. Those are all the questions I have for you, Mr. Allen. Thank you very much.
Thank you.
Thank you. Re-examination.
Thank you very much, Mr. Allen. I have some, just to clarify for the court and for Mr. Burrell, we have not been in touch in any way during this examination with Mr. Clark or anybody on the QSI team. I have had a couple of messages from Mr. Resk. I hope I have understood them, and I'm reluctant to ask for a break to just make sure I have those, because he's in a different room to me. But I believe I've understood them, and if you can just please bear with me, as Mr. Allen, there's just a handful of questions arising from your evidence. The first one is just a point that in the UAE, I'm told, and if you take it that this is the case, that a tax invoice is in accordance with UAE law and is sufficient for many of these transactions. And if that is the case, and assuming that is the case, is the best evidence the invoice rather than a PO, if a PO is not required?
Well, the invoice supplemented by the receipt is the best evidence of the payment, of course, but I can understand it would be a PO would tend to set out perhaps the scope of the works, but no, I think the invoice and the receipt from an accounting perspective confirms the transaction.
Thank you very much. And if I could just open, please, page 1281. And this is a progress meeting on the 31st of July 2019, which I think was one of the documents opened. And certainly there were a number of meeting reports open to you in your evidence. And if you could see at point 2.2 that there's a discrepancy between the dashboard for the actual complete at 89.47% and the actual situation on the site of 80.8%.
Sorry, Mr. Dillon Malone, actually this wasn't one that was open, just for the record.
Very good. I did hopefully correct that a little, but there were a number of other meeting reports opened, and the suggestion is that reliance is being placed on these dashboards and information provided at meeting reports by MESC, when I'm suggesting that the baseline and the actual progress on site may not be accurately reflected in these meeting reports and in the dashboard that was open to you. Do you have any insight into that?
Well, just to remark that this was in August, so it suggested that there was 80% progress. So some 3 months later, at the date of termination, progress is reckoned to be about 85%, which might be consistent with the apparent or at least the pleaded problems leading up to the termination.
Yes, and I think if I could ask you to look at page 4363. 4363, please. Kareem, please. 4363. 4363. Here's one on the 23rd of October. and I think this one was open to you. And you see at 2.2a, there's a reference to R05. And I think R05 refers to the aluminium balustrade. Is that correct? Are you aware of that?
I'm not aware, I must say. I can't confirm that.
My instructions are that it is, and I'm told also that the R03 is the correct reference for the actual baseline program, and that what is here being discussed is in fact the progress solely in relation to the glass ballast, the aluminium balustrade.
Okay, that would explain the well, what might be a discrepancy in that figure when we consider the overall progress.
Thank you. And if I could also ask you to look at page 3814. You were asked about the fourth so-called, as I think you mentioned, extension of time request, and the MESC's letter was open to you. And this is the response from the engineer dated the 11th of February 2020. And it refers to in the second paragraph, the failure to submit drawings, calculations, executing a mock-up and getting approval for submission to the engineer to comply with the project specifications and safety requirements, which are entirely obligation and liability. And then there's also a mention of the employer having been alleged to be responsible for the selection of Petra, which was the nominated aluminium subcontractor. And then further down, there's a reference to the 20.1 of the contract, etc. So I just draw your attention to this. Is there anything in this letter?
Well, I think you ought to ask the witness whether
Yes.
he's seen this before and has he taken it into account at all in
Yes.
coming to his conclusion.
Thank you. Thank you very much, Justice Field.
What's the answer to that, Mr. Allen?
Yes, Your Honour. I think I was alluding to the same issues in my discussion with Mr. Burrell, that the engineer's position as reflected in this letter was that the drawings calculations as we see, the execution of the mock-up, the wind load issues, those were all reasons, at least why the engineer had been citing that MESC were responsible for the delays to the balustrades.
Yes,
so I think this correspondence is reflected in my reports.
Yes, right. Thank you.
Thank you.
Thank you. I just have two more small points. The first, and this is, we don't have the benefit of a transcript overnight, and it's from my note and from my memory. And having checked with Mr. MESC, his evidence yesterday was that the IFC drawing, is it the
issued for construction?
Issued for construction drawing is not actually necessary. I think it was put to you by Mr. Burrell that it was absolutely necessary to have a issued for construction drawing in order to complete the post-tension drawings and in order for certain other works to be done. I think it was Mr. MESC's evidence yesterday that there are other drawings that were made available to MESC before the IFC drawing, which were I think a project drawing and I'm sorry, I'm just trying to find my note, a contract drawing and an authority drawing. And that they would have been made available before the IFC drawing. Is that something that is familiar to you? And have you heard of anything about that in this case?
Well, yeah, I mean, it's not necessarily the case that all works, cannot proceed until a set of IFC drawings are issued, and of course, IFC drawings can constitute tens or hundreds of individual drawings. So yeah, there's not a single point in time when all of the works can proceed. I suppose that's the relevant point.
Thank you. And similarly, again, with my apologies for not having a clear, absolute recollection of the words, but it's my recollection on a note from yesterday's evidence in relation to the table and the discrepancy between 79% and the 88%, that in Mr. Mesk's original evidence, he appeared to accept that there could have been a discrepancy. But then, having gone down to look at the further material, he then said at the end of his evidence that he thought both were correct. I understood you to say in your evidence on this that the figure in the far right box, that was correct and it hadn't made a difference. Is that correct?
Well, the point I was making was that the 88% hadn't been calculated by formula, but it didn't actually impact on the bottom right valuation figure, which was derived from the 79%.
Thank you very much, Mr. Allen.
Thank you.
Well, Mr. Allen, you've had a hard day's work, and the court's grateful to you for coming to give your evidence. You're released, and you go with my thanks.
Okay, thank you.
So tomorrow we'll begin at the usual time at 12 noon Dubai time. And just remind me of the name of the next witness up. He's going to be also, he's going to be the quantum man on the question of sales and rentals. Have I remembered that correctly?
That's correct. His name is Richard Paul.
Oh, that's right.
Richard Paul.
He's a Savills man.
Savills, indeed.
Yeah. Okay.
And he's ready to go.
Right.
You'll be grateful to hear, Your Honour, that my examination with Mr. Paul will be shorter than either the delay or quantum section today.
Very good. Thank you very much for that.
Thank you.
An assurance that I will be placing a great deal of reliance on.
Absolutely. Your Honour, I don't know if there is one other item. I don't know if you needed to, or if you wanted to discuss the legal issue that arose on the first day. Which
no, not now. I've not had a chance to take on board.
I understand
the materials you've supplied. We could have a look at that once the evidence is in.
Yes.
Understood. If it was necessary, Your Honour, it could of course form the subject of post submission.
Well, it could be part of closing. It could be. Well, what I particularly want. I mean, you've given me some extracts from Hudson or Keating, I forget now, and the particular point that I'm interested in is whether or not the grounds specified in the notice are the only grounds that can be relied on for valid termination of the contract. And my quick skin read through the textbook is that you have to work quite hard to dig out those bits that actually relate to that a narrow point.
Yes. Yes.
So anyway,
might I just very quickly, because I think I may be able to shed some light on it. And I did have a chance to look at this material, and I also did a little bit of research, and I do have an extract from Keating, which I think would be very helpful. So I can also forward that to you by email and to Mr. Burrell.
Yes, okay. I mean, it's a point.
I think it could be dealt with. My sense is that looking at the material that Mr. Burrell provided and that I'll be relying on, I think we could do it in a discussion with you, most useful.
Well, we'll see. It's a point in the case, clearly, and it can be, that means it can be dealt with in closing submissions, if you like, as a default possession. And for my part, it will, whether I ask you to do it in closing or whether in the part of the oral hearing, will really depend on what I want to concentrate on at that particular time. Very well. The court is adjourned until 12 noon tomorrow. Thank you very much.
Thank you very much.
Thank you very much. Thank you.